this. Good afternoon and welcome to the Appellate. Good afternoon and welcome to the Appellate Division First Department. I will begin with the call of the calendar. Please know that we have 5.5 hours of requested argument time. So please ask for the time that you actually need, not the time that you want, understanding that this court is fully familiar with your case, the briefs, and the record, and sometimes more than you wish we were. So, People versus Idris Sutton.
Appellate requests 3 minutes and 2 minutes rebuttal.
Okay,
Respondent requests 3 minutes.
3 and 2 and 3. Great start. Okay, 40 BA versus DHCR. Okay.
Respondent requests 8.
All right, 5 and 2 and 5. And please understand that even if I cut your time, if my colleagues have questions beyond that time, I will permit them to keep asking questions, okay? All right. B. Alicia versus Dominique S. is submitted. Grant versus 1137 East 223rd Street has been withdrawn. Medina versus Jet Aviation Flight. Okay.
Respondent requests
6 and 2 and 6. People versus John Thomas is submitted. Gibson versus Castillo.
Appellate requests 5 and 2, Your Honor.
Okay. 5 and 2 and 6. Beth Israel versus New York State Office of Medicaid Inspector General.
For the appellate, 8 and 2.
For the respondent, 7.
Okay. 7 and 3 and 8. CrowdPay versus StreamNet.
I'm the appellant. I represent StreamNet. I'd like to request 5 minutes, Your Honor.
Okay.
No objection, Your Honor. Respondent.
Okay. We're going to do 4 and 1 and 4. People versus John Cabrera. You scared them away. Would you like to submit?
I guess so, Your Honor.
Thank you. Torres versus Quito.
Appellate requests 6 and 2.
Okay.
Pioneer request 3.
Okay.
Good afternoon, Your Honor. Respondent Helen P.M. Mechanical requests 5 and 2.
Okay. Now look, we are doing this, we're arguing this case together. You've got 15 minutes, so that has to get divvied up between the parties. So, did you hear the other request?
Well, I think it would be generous of them to allow me 5 minutes.
That generous is nice, but let's be realistic.
4 minutes, 3 minutes?
Okay, so, and I haven't heard from you. That's not happening.
I'll take, whatever loses.
Okay, and who's here for the plaintiff? How much time are you seeking?
I asked for 6 and 2.
Okay. Now, there are 2 direct appeals, correct? There was one appeal, you have an appeal as well. And how much time?
3 minutes.
Okay, and you are with
Pioneer.
Pioneer. Okay, so Pioneer is looking for 3. CSRG, right? And you are with? I'm sorry, I transposed them. And PI Mechanic. Okay. So there's no one here for 1711? Okay. Okay. So let's do this. Plaintiff, you'll have 6 and 2. Pioneer, you'll have, do you have a cross appeal? Pioneer? You have a direct appeal and a cross appeal, right?
I have no opposition.
Okay, so 3 minutes for you, CSRG, 3 minutes for you, PMIC, 4 minutes for you. Okay? All right. People versus Carl Johnson.
Appellate requests 3 and 2 for rebuttal.
Okay?
Respondent requests 3 minutes.
3 and 2 and 3. NGM Management versus Bear Burger Group. Okay. Okay. 7 and 1 and 7. Doe versus Wilhelmina Models.
Appellate request 82, Your Honor.
Okay.
Good afternoon, Your Honor. Respondent Wilhelmina, request 7.
Okay.
Good afternoon, Your Honors. We're for respondents New Sunshine and Calcan, and with permission of the court and Andrew Nordahl will be arguing. We request 8.
Okay, is this a Pro Hoc Vici application?
Yes, it is.
Okay, that application is granted, and you know we have thousands and thousands of New York lawyers, but you're welcome. Okay, so 7 and 2, 6 and 6. People versus State of New York versus National Rifle Association.
We would request, National Rifle Association request 83.
Okay,
The Attorney General's Office requests 8, Your Honor.
all right. 7 and 2 and 8. And that's for all three matters. And National Convention versus FB International is submitted. First case on the calendar, People versus Idris Sutton. You may proceed.
May it please the court, my name is Laura Boyd, counsel for Idris Sutton, the appellate. In People versus Campaniano, this court held that the federal drug statute was not a valid predicate under New York law.
I was on that case, as I'm sure you are aware. And you, I am sure, are also aware that in that case, the holding was quite limited since this court did not have access to the underlying accusatory instrument. So we were bound by the small record that we have. That's not the case here.
No, we have the accusatory instrument.
Right.
But that doesn't help us. Nowhere
think
in the
it does,
accusatory instrument does it allege that the defendant knowingly did anything. It just specifically states that he did possess or have under his control with the intent to distribute a controlled dangerous substance, cocaine or its analog. So you can't look to the accusatory instrument to find knowledge if it's not in there.
Hasn't this jurisdiction done that already? Several times. And
If you're-
found this particular statute a permissible,
I believe you're referring to Simmons, where the court did look to the accusatory instrument.
Right.
But in that case, the accusatory instrument made clear that the conduct was knowing and that the person knowingly possessed the particular kind of drug. We don't have that allegation in the indictment. And you can't read in an allegation if it's not there. I know that the respondent feels you can take the statute and pick and choose facts from the accusatory instrument and mash them together.
not pick and choose, but compare what part of those factual allegations would satisfy the statutory requirements.
Well, first, it doesn't satisfy it because it doesn't plead that it happened knowingly. Secondly, yes, courts can look to the accusatory instrument, but it's for a limited purpose, only to discern which course of conduct was engaged in, whether it was the manufacturing, the dispensing, or possessing with intent to sell. But all of those courses of conduct are not a valid predicate under New York law because they all have the same infirmity, that the knowledge requirement or element of the New Jersey statute is broader than its New York counterpart. So there's nothing to look at the indictment for because there is no course of conduct under that indictment that could possibly be sufficient. So if the court does look to the indictment, then this indictment in particular is not sufficient because it does not allege knowing conduct. And you can't read facts into the
Doesn't the
indictment.
indictment refer to a statute, a New Jersey statute, which incorporates the knowing and purposeful element?
Well, that's what respondents arguing. Basically, you could say because the statute requires that the defendant know he possessed the particular kind of drug, we can take that knowledge and read it into the allegations set forth in the indictment, and that makes it a complete crime. That's not the way it works. If there is, allegation is not in the foreign accusatory instrument, the court cannot rely
So
on it.
you're saying that we should ignore the fact that a grand jury received the factual allegations, the charge that includes a knowing element, and we should not assume that they married those two together?
Well, we shouldn't for this reason, because the New Jersey statute does not require that a defendant know the particular drug involved. Then the grand jury didn't have to find that. All they had to find was the defendant had knowledge that he possessed a controlled dangerous substance.
Okay,
So
right.
that's what we could read in.
all right.
Good afternoon, Your Honors, and may it please the Court. Stacey Nadell for the People. As the panel has noted, Simmons is on point here, and the lower courts properly considered the accusatory instrument in congruence with the New Jersey statute at issue. The accusatory instrument, just to note in the entirety of the relevant statutes here, says that the defendant did possess or have under his control with intent to distribute a controlled dangerous substance, cocaine or its analog, contrary to the provisions of New Jersey Statute 2C35-5A1B3. That denotes the specific subsections of the statute that encompass the knowledge requirement, as well as specifying that the drug is cocaine. So the statute specifies that the knowing possession was cocaine, as well as the accusatory instrument when you look at them together. And that's exactly like what happened in Simmons with the Pennsylvania statute at issue there. And
I guess the argument is that it has to be spelled out. You can't incorporate by reference. That's what I heard, or that seems to be what I heard, right? I mean, that's what's going on here, right?
yes, Your Honor, that is what's going on here. However, because the statute was so specific to denote the subsections that defendant was in violation of, the knowledge requirement is encompassed there. And
I mean,
this
you can't
is-
ignore it. I mean, that's the thing. Even though it wasn't specifically spelled out, the fact that it was incorporated by reference, you still, I mean, it's still there. It still has to be proven to the jury ultimately to get a conviction, right? I mean, right, the fact that it's not spelled out doesn't matter as long as the key point is that it is incorporated by reference. So if you look, you know where it has to be. That's an element that still needs to be proved. Even though it's not spelled out, it's there by incorporation, it still has to be proved, right?
Yes, and per defendant's guilty plea where he had presumably the allocution that, to have a valid guilty plea, all of the elements need to be allocated and accepted. And because that guilty plea was accepted and this is now a conviction, the accusatory instrument and that conviction shows that the knowledge requirement was accepted and incorporated there.
I mean, curious would be I would be curious to see in New Jersey whether or not incorporation by reference is permissible. I mean, obviously somebody may have challenged that. And it seems to be okay to do that, right? You don't have to spell everything out. They just do a shortcut.
Not necessarily a shortcut, but it was specifically listed in the indictment. There was no challenge to the indictment, and there is none on this appeal. The issue really mainly is whether this was a valid predicate, and this predicate was valid. It establishes the elements that make it out to be equivalent to a New York felony.
Do you agree that when you strictly compare the elements of the New Jersey statute with the New York statute, just the elements of the statute, that they're not enough?
No, Your Honor. To that, I would argue that even if you're looking at the New Jersey statute, just subsection A, where it says knowingly or purposely possessing a controlled dangerous substance, we have the New York felony of criminal possession of a controlled substance in the 5th degree, which similarly says knowingly and unlawfully possessing a controlled dangerous substance. And then if you move further to subsection B, where as charged in New Jersey here, the specific drug of cocaine was charged under that statute, we have knowing possession of cocaine as a felony in New York. So even just by looking at the elements of the statutes as charged, the New Jersey statutes are equivalent to felonies in New York. And that was the same as with the Pennsylvania statute, and including the accusatory instrument just further strengthens the comparison between New Jersey and New York.
Okay, we have gone way over time, but I thank you.
Thank you.
All right.
Since we're over time, I won't belabor the point, just 2 comments. If it were even permissible to read in a knowledge element from the statute into the accusatory instrument, which we maintain it is not, what knowledge element are we reading in? We're reading in the New Jersey one. which doesn't require knowledge of the specific drug, just that the defendant knew he possessed a controlled dangerous substance. That's at most what we could read into it, because that's the law in New Jersey. As for the fifth-degree argument that there could be fifth-degree criminal possession of a controlled substance, without belaboring the point, first of all, Campaniani rejected that argument. And I would direct the court to the reply brief, pages 7 to 12 in the reply brief in Campaniani, and it will lay out the argument as to why fifth-degree criminal possession of a controlled substance is not equivalent.
Thank you.
Unless you have any other questions?
Thank you. All right. 4040 BA versus New York State Division of Housing, Community, and Renewal. I don't know. Give me 1 second so I can set the timer.
Okay.
All right, hold on. Can I get some assistance up here? The clock is going in reverse. And we can't have that because then I have to do math and listen to legal arguments. Okay, now I fixed it. Thank you, I got it, thanks. You go ahead, sorry.
Good afternoon, Your Honors. My name is Randy Gilbert, and I'm here for the appellant. We're here because the Supreme Court improperly dismissed an Article 78 special proceeding because it didn't comply with its motion requirements. I'll rest on my brief with that issue. They also held that DHCR did not act in an arbitrary and capricious manner at page 5 of the record. The facts in this case are relatively undisputed. In May of 2017, the owner undertook to do major capital improvements
Give me a minute.
to the building for a cost of over $1 million. It spent $321,000 for a repiping of the property.
But the issue is not how much they spent, right? The issue is, did they properly provide the documentation that is required by DHCR, right? Because even if you spend the money, if you
They
don't
did, Your Honor.
document,
They did, Your
let
Honor.
me finish my comments.
Sorry.
You have to be able to document what you have done. And here, there's no question that DHCR asked for additional documentation, and that was not quickly forthcoming.
The documents were provided to DHCR no later than April of 2019. The record was complete by April of 2019, prior to the HSTPA. The only questions the DHCR asked subsequent to the HSTPA was they asked the owner to redo the amortization schedule based upon the HSTPA. That was the only documents that were submitted subsequent to the enactment of the HSTPA. My client was entitled to the MCI. They complied with all the work. The order that DHCR
But when you
issued.
say entitled, the decision had not been made at that time yet, right? Irrespective of the fact whether all the documents were in, the determination had not yet been made as to whether they were entitled to it, correct?
Correct. The work was completed and the statute was complied with. The DHCR order issued in December of 2019 specifically said they weren't entitled to the modernization of kitchens and bathrooms solely because of the HSTPA, not because any document was missing to substantiate the work. They said that it was group work under the HSTPA, though the HSTPA doesn't define group work, so they were no longer entitled to the increase. This was an improper retroactive application of the statute. The statute said—
No, it's not, I know you argue that, but the fact that you argue it doesn't make it so. A determination is not ready for complete assessment until all of the documents that the agency says they need is there. So by the time that all of the documents that had been requested were received, the HSTPA was already in effect, correct?
No, the documents were submitted prior thereto by April.
And they asked for a supplement, no?
The supplement was based on the HSTPA that they wanted them to fix the amortization
The
schedule.
point is that they weren't assessing it until they had all of the things they requested, correct?
Correct, Your Honor, but they had all the stuff that they needed for prior law. The prior law my client, as of April of 2017, had provided every document that was necessary for them to comply with the statute in effect as of 2017 when the work was performed. They were entitled to the
And when was the application put in?
August of 2018.
Okay, so it wasn't, you keep on saying the work was performed in 2017. That's nice, but until there's an application before the board, it doesn't mean anything, right?
Application was submitted in 2018. My client answered DHCR's request for additional information. By April of 2019, DHCR had every document necessary under the statute in effect in 2017 to determine the MCI.
You keep on going back to 2017,
Does that-
and there was no application before the agency in council, please.
Okay.
We do these cases all the time,
I understand.
okay? So we understand what's required and what the trigger dates are, okay? So the completion of the work is irrelevant. The issue is, when did you submit the application?
The application was in August of 2018, and by April of 2019, all of the documents that DHCR had requested to complete the application and determine it were in.
So wait, so let me just ask you, is your position that just because you put in all your documents, you have a substantive right?
Once
Don't you have to wait until you get a decision? Isn't that the whole point? That you don't have a decision, you don't have any substantive right. You have the right to get a determination, but if you're saying it's retroactive, it would only be retroactive if you had a substantive right at that time to that relief.
The MCI statute is very specific. If all the work is done and you complied with the statute, and DHCR has the documents, you're entitled to the MCI. DHCR could take years to decide an MCI or any other. It doesn't mean.
I don't believe that there's any case that supports what you've just said, okay? It is not upon the completion of the work. It is upon the submission of the application and approval by the agency, okay? But you'll have time on rebuttal.
Thank you, Your Honor.
Counsel, we will hear from you.
May it please the court, Kwame Kosa for the Division of Housing and Community Renewal. The court is correct to point out.
How does this affect your adversary's argument? That Parquet was effective immediately, there's no dispute about that. And then Parquet also says apply to any determination issued by DHCR after the effective date. So in this case here, there was no determination as of yet.
That's correct, Your Honor. And
So that there was, DHCR at that point was kind of like, this is what we got. This is what, even if we thought you should get the MCI, based on the explicit wording of Parquet, which says it applies to any determination, they have to apply Parquet.
right, Your Honor, the petitioner's quarrel here is not with the agency, but with the legislature. The legislature specifically directed DHCR to apply the new law to pending applications. And the act of performing improvements or submitting an
Not
application.
even pending application, any determination they make
Correct, Your Honor. Any
after the
determination.
effective date of the Parquet has to apply Parquet. So that it has, regardless of pending, when you put it, however you, if they haven't decided that, if there is no determination, nothing's happening. But once they have to make a determination, at that point, it's Parquet.
Yeah, Your Honor, and that's correct. And since there's a clear legislative text on this issue, there's no reason to
There's
get
no
into.
way to wiggle out of this. At least I don't see it.
We agree, Your Honor.
Oh, okay.
And regarding the comparisons to Regina, I think the court would also be aware.
That's
here.
a whole different ball of wax.
Okay.
Regina's a whole, I mean, that's where the owners were.
Look back.
Went back and they did certain things based on prior about fraud and lookbacks and all that. I mean, that's totally.
Correct. And if the court is curious about the comparisons to Harris v. Israel, that case is also an opposite.
Let me ask you also this. I mean, they're not totally in terms of recovering what they spent. I mean, there's still the IAI.
That is correct. So the deputy commissioner's order also stated that they could recoup the improvements through IAI rent increases, and all the petitioner has to do
It's
there.
sort of like a subliminal message to them, like, okay, you know what, we kind of start with Parquet, but IAI might be your other alternative to come at us, right?
And with respect to that remedy there, I mean, the petitioner has argued that it was arbitrary and capricious because you have to wait until the tenant vacates the premises in order to take the IAI. But that's not a basis to conclude that the decision was arbitrary and capricious. There's no right to collect under the rent regulation law or to maintain beneficial regulations going forward. With respect to the undue hardship questions, there was no evidence in the record to support the finding of an undue hardship.
You know, actually, you make an interesting point because with MCIs, you can't bank on the fact that prior MCI approvals is going to get you an MCI approval on this go around.
No.
I mean, that's always up to the discretion of the agency. So there is, in terms of retroactivity, there's no black and white type of like this is it.
Right.
I mean, it moves around. It's just it's not static in a sense.
And also to clarify the timeline issues, the court has been very interested in that. Petitioners argued that the final application was submitted in August. That's not correct. The final application was submitted after the HSTPA. The agency requested additional documentation in October of 2019, and then those documentations were presented after that date. And then the final determination, of course, was in December of 2019.
Yeah, but all that to me, it all comes down to when the determination is going to be made. I mean, if it's before the effective date, you're good to go. If it's after the effective date, you got to apply Part K.
Unless there are no further questions, we would rest on our brief.
Thank you.
I'd like
So
to,
how do you get around the explicit wording of the statute that says any determination has to be applied, Part K applies?
Part K was to apply prospectively only. It was implementation as this.
How do you get around the word any determination, you have to apply Part K?
Because it would be if an application was filed, they had to apply Part K subsequent to the 14, not prospectively.
Huh?
That's not what the statute says. It says immediately.
Right, it immediately has been construed to be prospective, not like the statute in Regina where Part K,
So when you say that, do you mean that any pending application that has not yet been decided would fall under this rule?
Yes, if the statute says it's supposed to be applied.
So then that means that your case falls under this rule because there had been no determination.
No, Your Honor, it would be an improper application because my client, it was immediately means prospectively, which means when an application was filed on 6/14 or 6/15 of 2019.
That's not what the statute says. It says immediately.
I understand that.
Any pending cases not previously determined are now subject to this rule.
That section has to do with a different part of the statute. And I
Also,
don't-
is it your argument that you have a vested interest in this MCI the moment you submit an application?
The moment we submit the application, we're entitled to the MCI to be determined.
Do you have a vested right in the MCI the moment you submit the application?
If we
Because it
comply-
seems to me that if we follow that theory, that then the decision of the agency is an administrative one. It doesn't really matter.
If we've complied with the law, yes, we would be entitled to the MCI. They have a vested right to have the law applied at the.
If you comply with the law, and that's a determination that the agency makes, right? So so your vested right comes in when the agency says, yes, you've complied with the law, you therefore are entitled to this. And that didn't happen here.
We did comply with the law in 2017.
That's
The
your
law
argument, but
changed
the
in
agency did
2019.
not find that, correct?
The agency found that they were bound by the HSTPA, not that we didn't comply with the law in 2017.
Did the
Okay.
agency issue a decision before the law changed that you had complied?
Unfortunately not. I'd like to address the.
No, we're out of time. Thank you. We have your brief and the record. Thank you. Medina versus Jet Aviation.
Okay, here we go.
Please have a seat for a moment. I need some. All right. Councils on People versus John Cabrera. Bring them in. Thank you for your patience. My apologies. Who just arrived? All right, counsel, I am going to permit you to make an application, but this court starts at 2 o'clock sharp. And you are interfering with the call of this calendar, and your colleagues don't appreciate it, okay? Yes, sir. So, who is here for the defendant? I am here. Okay, how much time would you like? I asked for 15 minutes. That's not happening, so give me a realistic number. You missed the speech, so.
I'll take 7 minutes up front and 2 on request. On request 5, Your Honor.
3 and 1 and 4. Have a seat. You may proceed. Here you go.
Good afternoon. May it please the court. Emily Matthew from Thompson Hine for defendants appellants Jet Aviation Holdings, Jet Aviation Teterboro, and General Dynamics Corporation, which I'll refer to as the Jet Aviation appellants, as well as Third Point LLC, Daniel Loeb, and Terragram LLC, which I'll refer to as the donor appellants. I'd like to first address the personal jurisdiction issue, which concerns the Jet Aviation appellants. The claim here relates to an alleged personal injury that occurred at Teterboro Airport in New Jersey. The Jet Aviation appellants conducted no activities in New York with a substantial relationship to the claim. Taking first Jet Aviation Teterboro, respondents' argument that jurisdiction exists is based on one contract that Jet Aviation Teterboro had with its customer, which is Third Point, which is based in New York. But that contract was for aircraft management services, which were performed at the airport in New Jersey or on flights going to and from the airport in New Jersey. As for the other
If you boil it down to minimum contacts, let's strip everything else and we get down to the old law school analysis of minimum contacts. Jet Aviation, or the whole Jet group, including the parents, there's no connection in New York, right? I mean, other than this one contract that they tried to argue that was entered into here, nothing else was here in New York, right?
That's right. Everything was occurring. It was an aircraft services agreement, so the agreement was fully performed.
And Jet Aviation Flight has been let out already, right? The court
That's
dismissed
right.
them already.
Yes, they're out on the basis of no jurisdiction.
Right.
So there's
And none of those defendants are New Jersey corporations, correct? And none of them have a principal place of business in New Jersey.
I think Jet
New York.
New York.
I'm sorry, no.
York.
I was like, what?
We don't care.
Oh, I'm sorry, New York. You're right, I'm sorry.
correct. None of them are New York.
None of them are New York corporations. None of them have a principal place of business in New York,
That is
correct?
correct.
And the plaintiff is claiming that the pilot crew were directing him how to, is that correct, right? The crew. And that defendant's still in.
Yeah, okay, so let me turn to that part of the argument. So that relates to the donor appellants, which is Third Point and Mr. Loeb and Terragram. And that turns on this respondeat superior issue and who directed the pilot. The pilot, as you, I think, were referring to, is employed by Jet Aviation Flight, which has been dismissed.
Right.
That was his general employer. So the question here is,
Yeah, but in terms of the flight crew, which is Jet Aviation Flight, right? Jet Flight is doing the flight crew or in charge of the flight crew, and then the donor defendants here, there was sort of agreement where they were getting involved in terms of paying them, compensation them. I mean, there was a little bit, it's sort of like, kind of melding together, a commingling of who's what, where, right? So there's a little problematic there. It's not very clear cut, right?
I think that, so Third Point was paying for the services of the pilot, so they are transmitting money to Jet Aviation
I mean,
Flight.
this is a pre-answer stage we're talking about, right?
Correct.
So we still have a little bit ways to go, right?
Yes, but I think we can, so the donor appellants were a hedge fund, the CEO of they're not going to, the presumption that, basically the respondent is going to have to show that those donor appellants were controlling the pilot's work on an operational day-to-day basis. But
Well, that goes to like beyond the pleadings then, right? When you're saying that they're going to have to show X, Y, and Z, I mean, you can't do that at the pleading stage. They can only allege what they have, right?
Well, I think as a matter of law, it's very useful to look at the agreements. So for example, the dry lease agreement says that JA Flight is solely responsible for the actions and inaction of the flight crew, and that's on page A137. So as a matter of law, JA Flight retained control over the pilot's actions. And of course, they were also employing him.
So for example, what are the allegations against Mr. Loeb?
So Mr. Loeb, there really is nothing. So even if Third Point itself were liable, which we would say it can't be, he's the CEO of a hedge fund. There's no reason to think he would ever be directing a pilot. He was not on the premises. He had no control over what happened that day. He just happens to be the CEO. And similarly, Terragram is the other entity. They are the entity that controls the Loeb family's personal finances.
Okay, and what are the allegations against Terragram?
There are no really non-boilerplate allegations against Terragram. I think they are included, and there's the record will show Terragram, the name does appear on some of the documents because they were Mr. Loeb's personal financial management company, and he made a donation to cover the cost of the flight. So at some point, Terragram engaged in some correspondence to get documentation for the tax records.
But nothing about, there are no allegations about those companies directing the way that the hangar is set up, or the way the plane is set up, or the way that cargo is
Being
loaded on the plane?
That's correct. There's
Okay.
other than boilerplate allegations, there's no allegations to that effect. And nor that they were on site, or would have had any reason to be directing the activities of a pilot. Again, I would just underscore that, we're, on the one hand, we're talking about an aircraft management services company that employed the pilot, and on the other hand, we're speaking about, a hedge fund, the hedge fund CEO, and a financial company, which are, it's just implausible to think that it was their role to exert comprehensive control over the on-site actions of the pilot. There is no reason to think that you would ever be able to show that the aircraft management company yielded that control to their customer, essentially. And again, we do have the agreement that says that JA Flight was solely responsible for those actions.
Thank you. You have time on rebuttal.
Okay, thank you.
May it please the court, I am Stephen Vaccaro, and I represent the plaintiff respondent, Paul Medina. This court should affirm the lower
Let me
court's
start with Mr. Loeb. How are you connecting Mr. Loeb to plaintiff's accident?
Well, Your Honor, I would first state that I discovered the parties that I've named in this lawsuit through pre-action discovery.
Okay,
So-
which is exactly what you're supposed to do, right? You have an obligation to sign the pleadings and
Correct.
say.
Right.
So that's not special.
Right, so
Let me just ask you, what allegations are in the complaint that connect him to this accident?
Well, it all goes back to that pre-action discovery, wherein we found emails where there were individuals who represented Mr. Loeb, and they directed the delivery person, the company who is handling the delivery person, to show up to the hangar and speak to Mr. Loeb's, and it's a quote, Mr. Loeb's.
How does that connect to the accident?
Well, it's impossible to say at this juncture, given the fact that we haven't had the opportunity to conduct.
So that's all you're saying? You have this hedge fund manager in because you found an email telling him to have someone connect with the pilot?
Well, he was named pursuant to.
Other than that, is there anything else that you have alleged that would connect Mr. Loeb to this accident?
There are allegations that the pilot directed the manner and path.
I'm talking about
talking
Mr.
about
Loeb.
No, I understand that, but it's also part of my allegation.
No. I need you to focus on my colleague's question, because we have several
I understand.
parties who are being sued here, and we're trying to figure out who should be in and who should be out. So focus on her question, please.
Okay, I'm sorry, Your Honor, can you?
Okay, let's go to the
Sure.
the company that writes the checks, Terragram. What
Terragram.
connection does that company have to the lawsuit?
Same thing, Your Honor. That
Just
they're
that
in the
email?
emails and that they're coordinating the delivery.
That's it, nothing else.
That's it, that's all,
Right.
as of right now, that's all I know.
Let's go to the companies, the JA companies, right?
JA?
Yeah. What connects JA to Holdings?
Well, JA Holdings is the one who's receiving the payment.
How does that connect to the accident?
Again, since I don't have discovery, I can't yet state what their level of involvement is.
You have to have some allegations, some fact allegations that connect the negligence to the defendants that you are suing.
I understand, but at this time, all I have.
So that's it. All
an
you have is
email
an email that said
and
that we
payments,
paid.
and payments.
Okay.
That are being paid to Holdings.
All right.
Correct.
I have a question. So
Yes.
the question I have is with respect to Daniel Loeb.
Yes.
What do you have in the allegations that will compel us to disregard the corporate form? He's part of an LLC. So what is there in your allegation that says that he's done something that's outside of the LLC so that he can be held personally liable? I didn't see the allegation.
Again, pursuant to the email, upon information belief, looking at the email, it looks like the donation is going to be made and that the individual is going to be getting some kind of a tax.
But that doesn't mean you disregard the corporate form. He's got to be doing something outside the protection of the LLC.
Judge, fair enough, but I
correct?
believe, my recollection is that Mr.
Look, the way I look at it is maybe on the complaint and please point out if I'm wrong, because I got like 18, 19 appeals. I could have missed something. But if there's an allegation in there that says that, this is sufficient for us to disregard the corporate form, or even better, he's the alter ego of the LLC, so he can be personally held liable. If you don't have that, that's something down the road later on, right?
Judge,
you see what my problem is, right?
Yes. Yeah, of course.
People have LLCs and corporations for a reason.
But my problem is I only have a couple of emails to go by.
You know what?
And in those emails,
there's always the big beauty of amending pleadings that we have in this state, very generously done. But at this point, I don't see how the person I don't see anything where I can hang my hat on and say, yeah, we could disregard the LLC's protections for Mr. Loeb here. And by the same token, with respect to the JA defendants, the JA defendants and their parents, where's the minimum contacts to New York? I didn't see any, forgetting about all the, everything else we have to do for personal jurisdiction, it boils down to minimum contacts. What do you got in the allegations there?
With regard to Jet Aviation Teterboro, there is a facility tenants agreement. That is an agreement between Teterboro and Third Point, okay, that allows Third Point's airplane to be housed.
Is that sufficient, that one-time deal, to actually satisfy minimum contacts?
Well, I would think it's at least a sufficient start, and we can then figure out whether or not the accident arises from that relationship. Thank you.
Thank you. You have 2 minutes on rebuttal.
So is there anything in there that compels us to disregard the corporate form of the LLC's protection?
No, Your Honor, I don't think so.
Just because he sends an email saying, I get a benefit, a tax benefit, I'm putting money in, that happens all the time with LLCs, right, with their principals.
And in Mr. Loeb's case, he was making a charitable donation because the flight was shipping relief supplies to
Right, humanitarian aid.
So he received some invoices that had, photos and.
But regardless, that's not sufficient, at least
Right.
at least unless I'm incorrect, sufficient allegations to disregard the LLC's protections.
That's right. And I'm describing the emails just so that it's clear, like they relate to the fact that he made the donation. They have nothing to do.
And Telegram is Mr. Loeb's accountant of financial planning stuff. They have nothing to, as far as I can see, they had nothing to do with this transaction here.
That's correct. They just happened to be on some of the correspondence because they were monitoring the documentation for tax purposes since it was a charitable donation.
Because Third Point, there's no dispute that Third Point is a New York-based company, right?
Third Point is based here in New York.
Got it. All right.
Third Point is based here in New York. Third Point's appeal is based on the lack of respondeat superior based on the fact
Right, we're not responding superior, and okay.
Yes,
All right,
that's
thank
right.
you.
I just wanted to touch on this issue of Jet Aviation Holdings receiving the payment and clarify that the invoices that were being paid were issued by Jet Aviation Flight. And so with respect to Jet Aviation Holdings, which is a parent company, and then its parent, General Dynamics, there is no reason to disregard the corporate form. And their ownership of their subsidiaries is not sufficient to exert jurisdiction over them, and it's not even a sufficient start because the cases we cite in our brief show common ownership. Well, sure, that happens when you have a parent and a subsidiary. That's the nature of it. It is not a sufficient start to allow the plaintiff to move forward with those entities. It's essentially speculative, and it's not enough to allow the plaintiff to continue forward and try to later establish that there's jurisdiction.
Thank you.
Thank you. I think
Thank you
that's
so
all.
much.
Thank you.
Gibson versus Castillo. You may proceed.
Thank you, Your Honor. May it please the court. My name is Moshe Bopker. I'm an attorney at Tain, Waterman, and Wurtzel, the attorneys for the defendant appellant, 526 West 158th Street, HDFC. This is a housing discrimination case. Plaintiff alleges that she was denied the right to purchase one of the apartments in the building based on her race and her child's disability. This is the motion to dismiss was initially granted with leave to replead. And on the second amended complaint, or the third bite at the apple, the court found that she had
Not a third bite at the apple, it's a permissible second amended complaint. Go ahead.
Correct. Well, I mean, it was the third complaint. There was a complaint, amended complaint, and then the second amended complaint. At the end of the day, there's no facts in any of the complaints, combined, apart, whatever, any way you look at it.
Are you kidding me? There's no facts?
Well,
None.
There are no facts that give rise to an inference of discrimination. Correct. The facts are almost all alleged upon information and belief. They're speculative and conclusory.
She doesn't need a video to establish what she says happened and what she says was said to her. Okay? So her allegations that she was told she couldn't get a copy of the board minutes that was considering her application because you don't speak Spanish sounds to me like a sufficient allegation on the basis of her protected class.
Regarding the minutes, first of all, the Supreme Court first found that that specific allegation was anecdotal, was not sufficient. Although
that's why we're here.
Understood.
So I'm bringing it to you. I hope that that signals to you how important we think that fact is. So how about you address why that would not be a racially charged statement?
Certainly, Your Honor. It's not that they did not say no to the minutes. It was a.
Did they provide her with translated minutes at any point?
No, because her application was denied after having reviewed, after having done the credit check, reviewed her application, found that she had 2 properties in Georgia, which were both under mortgages, which were in default.
And that's contested.
Well, I don't think it's contested that they were in default or there was some protections under the CARES Act, potentially. There was a foreclosure notice issued against one of them. And again,
I thought you just said they were both under foreclosure.
Well, no, they were both delinquent, Your Honor. One of them had a foreclosure notice that was issued.
That? Go ahead.
Sorry?
I don't think I misheard that, but you can continue.
I apologize if I misspoke. And so there was a very short turnaround because and again, the board is not, they're not lawyers or judges or anything like that. So when they see foreclosure, they see delinquency, they're not required to, and they certainly would not know to go and look at the CARES Act and apply it. They saw that there's someone who's applying to be a shareholder who's going to have financial obligations to the building, who isn't delinquent on 2 mortgages, and they, under the business judgment rule, they were free to reject someone on that basis. And again, I think when you look at the complaints in total.
You accept, of course, and I'm sure understand that the business judgment rule doesn't get a free pass on our discrimination laws in this country, right?
Of course, absolutely.
Okay, so that if there is a finding or if there is any facts that indicate some kind of discriminatory practices, right, that would stop that ball from rolling.
Absolutely, Your Honor. And I think the business judgment rule is simply that the board has the ability to not just disregard the mortgages that were in default. Again, that's from their perspective. As far as the discrimination, absolutely. But I think if you look through the complaints, there's no comments, there's no comparators. There's no one else who was.
Well, we do have the issue of the other African-American tenant who she raised, right? And that the circumstances of that interaction also raised some potential inferences of discriminatory behavior.
Well, I would suggest, Your Honor, that the fact that a summary proceeding was brought against someone who was of a protected class is not evidence in and of itself that it was brought for that reason. She, she happened to be a licensee who didn't have the right to remain in that apartment. The fact that a summary proceeding is commenced against someone of a protected class does not.
Counsel,
equate
what
with that
about,
was- I'm sorry.
yes, but let me just ask you, what about the additional applications that plaintiff's application was the only application that's been denied by the HDFC, and that no other African-American has been
Approved for a sale.
approved?
Well, so I'm glad you brought that up. So as far as the second part of that, as far as there are been no other African Americans who've been approved. First of all, just factually, it's inaccurate. One of the board members happens to be African American. I understand that's beyond the scope of the pleadings, but
Okay,
that's
but we're just looking at the pleading. So
Understood.
assume
But
that
she
those.
doesn't
Did that board member buy the apartment, or are they
Absolutely.
married into the
Oh
apartment?
no, they bought it as far as I understand it. Yes,
Right.
and so I think just, again factually, it's not an accurate statement. But I would just point out that the allegation is, and if I recall it correctly, is upon information and belief there have been no African Americans who have been approved. She doesn't allege that there have been any other applicants other than herself that were African.
Well, she would have no way of knowing, right?
Well, again, there has to be something that points out that this was based on her race or her child's disability. There has to be something that says a comment, disparate treatment, and I think, again, the case law gives you some idea of, and she points out the Zia case, which it was in federal court, but I think that it is a kind of a framework for looking at the board there changed the application process for them specifically after finding out that the wife was of a protected class. I think, again, there were comments specifically to another member of the same national origin. So I think there has to be something that indicates that it's. I'm sorry.
I just want to ask you, when you talk about the other African American, are you talking about Benny Jones?
I'm sorry.
Benny Jones?
No, I don't think they were Benny Jones, and the holdover was they weren't an applicant. I believe when it was converted to an HDFC, they were already there. I believe they were a tenant, and then the building was converted into an HDFC, so they were already there.
So you're disputing, what you're saying is that there have been other, but I mean, okay, why not do the discovery? The question really is just, does that raise an inference of discrimination?
I don't believe so, because, again.
If the only person who's ever been turned down is an African American, and the building only permits Latinos to be.
Well, if I may respond, I know I'm over time and I apologize. Very quickly, regarding that, in order, even if assuming that we're correct, that she was the only African American to ever been denied by the building, she would have to allege that other people who were of a different or not of her protected class were similarly situated to her. In order to be similarly situated to her, they would have had to have mortgages on properties, be in delinquency, having foreclosures. They would have to be comparable in material respects, not just they happen to be of a different.
But that's a summary judgment motion, right?
Well,
That's
I
not a
think
motion to
I
dismiss.
certainly would be, but I think even on a motion to dismiss, there has to be something that permits the inference. I appreciate
Thank you.
Your Honor.
All right. You have 5 minutes, ma'am.
Your Honor, in discovery, I did ask.
Lower the mic so we can record you. Go ahead.
Thank you. In discovery, I did ask if there were any other African Americans in the building, and I was told that they do not know anyone's race in the building. In addition to that, Your Honor, both of my mortgages were covered under the CARES Act during the COVID-19 pandemic, and once I received the shot, I asked the mortgage company to re-implement the payments, and I sent them the paperwork for that. The reason why I filed this lawsuit is because when they said no, I scratched my head. I couldn't understand because the managing agent told me that I was qualified and that.
And as I understand it, your offer was a cash offer
Was a
to
cash
buy
offer.
this apartment, so that there was no issue about finance, there was no issue about whether the co-op was going to be left holding the bag if you couldn't pay, because you were going to buy that apartment
cash.
Correct, Your Honor. I've had deposition testimony from residents who cried and told me that the board president said he does not like black lawyers. He's like Trump. He only likes white lawyers. And he's one of the person that were making decision on my application. Another board member said she doesn't like Haitian immigrants and they should leave the country. So there is an issue in that building, and I am determined to proceed with this lawsuit because the people there deserve better than what they're getting. The issue here, Your Honor, is that everyone has a right to purchase a home if they can qualify for it and if they can afford it. They should not be using issues such as not being Latino or not being of their own heritage to let people live in the building or not live in the building. No other person's application was denied other than mine. And that was told to me this week by the managing agent. I'm the only person that has been denied an application to purchase in this building. Your Honor, I rest on my brief, but I do believe, Your Honor, that at this early stage of the case, the judge did not abuse any discretion and that we should proceed on with discovery. And if we do proceed on with discovery, more issues will arise from other residents who are finally feeling free enough to be able to say something about the board. Thank you.
Thank you. You have 1 minute.
Thank you, Your Honor. This here. Just to very quickly respond, just to point out that there's an ongoing financial obligation in the building, not just buying it. There's every month, and this is an HDFC.
I know that.
I know. I just wanted to clarify that, Your Honor.
But obviously, if you don't have a mortgage over your head, carrying the HOA is a lot easier.
Oh, no, it certainly helps. It certainly helps. I just wanted to point that out, that it was, again, if she falls into default here, hypothetically, then, again, that's something that they want to take into account when they're looking to buy the building, or to sell, permit the purchase, I should say. Regarding, I just wanted to point out that one thing that was not mentioned earlier, well, and I guess let me take a step back. Secondly, all the alleged facts that she's, kind of talking about depositions, that's nothing that's in the complaint. And again, we have to analyze the complaint. And obviously we dispute probably all of them, but that's beyond the point. The one thing I'd like to add that I didn't mention earlier was simply that even from the complaint, again, the scratching her head and saying, well, this was, what was the basis for it? Well, shortly after her application was denied, her own attorney wrote a letter saying, we understand there are financial issues that she has with these properties. We'd like the opportunity to explain them. The board was free to say, we are not going to look past them and to deny the application. I thank you, Your Honor, for your time. Thank you.
Thank you. Okay. Beth Israel versus New York State Office of Medicaid Inspector General. You may proceed. You have 7 minutes.
Thank you. Thank you. May I please the court? I am Dan Hurto. I'm with the law firm of Nixon Peabody, and I represent Beth Israel. I am here today because there was an audit conducted by the Office of Medicaid Inspector General, OMIG, of a OTP, an opiate treatment program that was run by Mount Sinai and Beth Israel. In that audit, they looked at 2 different sections of the program. The program really has 2 elements. One element of the program is administering and giving medications to patients. The other part of the program is the clinical part. Clinical part is where they bring the patients in and they speak to the patients. They put together potentially other treatments for them if they need mental health services, physical services, whatever it might be that they need, they try to assist that person, sometimes even housing services. When they conducted this audit, they looked at 1.9 million claims that were made over 3 years from 2014 to 2016. And when they looked at those, they did a sampling. So they took out 100 out of that 1.9. And when they looked at those 100, they found that there were some...
You're basically asking us, you're challenging the audit itself, right? You're challenging the Inspector General's process in terms of how they audited these claims, right? That's kind of, we're sort of like in a situation where we're going to be looking over auditors and how they did things. I didn't see in the record, maybe I missed it, but did you have an expert that comes in and say, you know what they audited was completely off the charts. This is not the correct audit. This is not how it's done. That would have been more helpful, I think, to me at least,
Well,
I didn't see that unless I missed it.
Well, Your Honor, there are two different things. So we are not
Understand,
challenging we're not challenging the audit itself.
Right.
Okay, when it comes to whether or not we met the requirements for providing a
But
plan.
didn't you challenge the methodology of that audit?
That's what I was going to say. There's two parts to what our arguments are. So one argument deals with whether or not there was substantial evidence and whether or not there was a treatment plan for these patients. Our argument there is that we absolutely had treatment plans for these
Yes,
patients.
but your argument.
And the other argument.
Wait a minute. Your argument, if I understood it, was Medicaid. If you look at all the totality of this patient's records, you can discern a treatment plan from it.
That's correct.
Yeah, well, Medicaid, how many Medicaid claims have to be assessed by this department that the onus should be on them to review all of the medical records in order to assess what your hospital's treatment plan was? The statutory framework very clearly says you must provide X, Y, and Z in this form. Why should you be alleviated of that statutory responsibility? You want to get paid from Medicaid? This is how you have to document it.
I'm not asking Medicaid or OMIG to do anything other than what they're responsible for doing. What happened in this case is our
So
client, Mount Sinai-
wait, because you said, I'm not asking them to do anything they're not responsible for doing. Did your clients do what they were responsible for doing?
Absolutely.
In providing the documentation in the form required?
Yes. The form required, there is no form
Okay.
required. There are certain things that are supposed to be in the patient's file. Okay, there's certain information supposed to be in the patient's file. There is no form required. What happened in this case?
Doesn't it say you have to have a treatment plan?
Correct, and the treatment plan.
So,
is made
so
up
they
of
have
the
to go
records.
through the chart to figure out what that is? Isn't there like a piece of paper that says client X, treatment plan, A, B, C, D?
A document that says treatment plan at the top, A, B, C, D, is not required by any of the regulations. What happened here was this program, which is one of the best run programs in the country, this program decided that best practices would be to come up with a single document like you just described
Okay.
that said treatment plan at the top and had information about each patient. That document that they created to help their counselors is not required by the regulations at all. They came up with it, so they get hung by their own petard in this case because they come up with the best practices. So what OMIG does is they said, okay, show me that document. Well, that document's not required. What's required is to show that you have, through nurse counseling, through meeting with counselors, through meeting with doctors, that you have put together a plan for the patients. And that is exactly what happened. Now, I'll tell you, there was testimony here, and we painstakingly went through all of the records for each patient that was involved in these claims. And we put in that evidence to show that the information necessary to show there was a plan was contained in the records. And for these few patients, we did not have that form document because it got lost because of a filing mistake. Okay. So it's not there because of that. But we had testimony. Then, on top of that, for those instances where we didn't have that form that was created by Mount Sinai and by Beth Israel, what we have in that case is people actually coming and testifying, real evidence. Counselors testifying, yes, I remember that patient, yes, I filled out that form. Not only do we have that, but we have circumstantial evidence because then we introduced work reports. All of the counselors had, and they were given work reports from their supervisors that would list all the things they were supposed to be doing for the patient, and they had to initial and check off whether they did it. The missing treatment forms, these forms that were made up by my client, which aren't required, they had indications in the work reports with their own signature that they had done the report. And we even had one case where the counselor was so upset that this form couldn't be found that she went back and dug like crazy and found the form. We bring it into the hearing. Evidence, it's accepted in as evidence. She testifies about it, says how upset she was that it couldn't be found. We have it, and they give us no credit for it, even though, and
because
the
it
answer
wasn't
is, the
signed,
answer is
right?
because you didn't have it at the time of the audit. So it's
I thought it was because her copy wasn't signed.
No, that's a
That
different
that's
case.
a different
No,
one.
this case.
Now,
is
let me say this, counsel, because you have asserted what I would consider personally as reasonable arguments. The problem I have is I'm in an Article 78 posture. So how, and I have been reversed on my ear on Article 78 cases where I go against the agency. So how, on this record, do I have the power in this court with my limited review power to overturn this?
Well, this is a substantial evidence question. The only real evidence that was put in during the hearing
Yes,
was
the problem
evidence by-
was the decision arbitrary and capricious?
Well, there's two questions. On the law and on the rule and on the regulations, was it arbitrary and capricious? And the answer is it was, because the ALJ was looking for a document that said treatment plan at the top and was a document we had created to assist the counselors. Instead of looking at the evidence that came in that showed that what is supposed to be there in the patient records, which constitutes a treatment plan, was there. Also ignored the fact that we had evidence, direct evidence and circumstantial evidence that these forms were actually filled out.
But as my colleague pointedly states, at bottom is there substantial evidence to support the ALJ's finding? I'm hearing everything you're saying, but if there's substantial evidence that goes the other way too, yeah, but a problem. And how do you, and this is something maybe you want to think about. Did you cite Atlantic Care Management LLC versus Ives as a third department case? That had similar situation here, right? And it's a 212 AD 3rd 132. I didn't remember seeing that. Did you cite that?
I couldn't stand here and tell you one way or another.
I read
What,
that. But
yeah.
it's a little
You'll have
problematic.
time to think about what we've asked you for rebuttal.
Thank you.
We'll hear from you.
Good afternoon, and may it please the court, Blair Greenwald on behalf of the state respondent.
Counsel, you've heard your adversary say that that form is not required. What do you say to that? And if he's correct, aren't you really putting form over substance?
He's wrong. Both the OMIG auditor and DOH in the fair hearing determination made very clear that they did not require a template form at all. Rather, what OMIG did, and the OMIG auditor testified about this in detail, was he looked at the entire patient file very thoroughly. Beth Israel was allowed to submit as much documentation as it could, and the OMIG auditor looked at that very thoroughly, but couldn't find all of the necessary requirements that the regulation lays out. In particular, for example, the OMIG
So what I
auditor—
suggested should not be expected is exactly what OMIG did anyway.
They did, yes.
Okay.
And the OMIG auditor explained that he looked at these progress notes, these workload reports, but couldn't see the signatures of all members of the multidisciplinary team. Even opposing counsel here notes only, the testimony of a single witness or a single person who filled out these notes, whereas signatures of all the members of the team are required. The OMIG auditor also explained that there were not summaries of the patient's progress on each of the treatment goals.
The bottom line, it sounds like you're arguing that, he's arguing one thing, but you're saying there's substantial evidence to support the ALJ's decision right here. I mean, I'm already ticking off all the stuff already, and it depends on how you want to weigh this. And this is not something that the courts venture into, right?
That's precisely correct, Your Honor. There's substantial
How much
evidence.
was it that they got clawed back? Was it about 10% clawback versus in terms of what they're asking to disallow? About $7 million was disallowed, right?
That's correct, Your Honor.
Over
OMIG
about
found,
$74 million paid out.
there was $82 million paid out, and they were required to
math
pay
is
back.
off, sorry.
That's correct. But just as Your Honor's pointing out, as just a very rough indicator, there was an 11% error rate found in the sample, and they were required to pay back only 9% of the Medicaid funds that they were.
And they had an opportunity to save themselves even more if they resolved the case before.
That's correct, Your Honor. They rejected OMIG's settlement offer in advance. I also just want to point out two quick things. One is that the overpayment determination, as this court has acknowledged, is not a punitive measure, as Beth Israel seems to suggest. OMIG here did not impose any kind of penalty, like excluding Beth Israel from the Medicaid program or fining it and requiring them to pay the government money from their separate revenues. Rather, this was just OMIG requiring a refund of the state's own money because it was improperly paid out because Beth Israel had not submitted the necessary supporting documentation for those claims. And the last thing,
We're talking about evidence or documentary evidence that was based on, it's all paper intense back then, right? That was part of the problem too, right?
there was both paper and electronic records here,
But
Your
now
Honor.
it's
That's
going to be simpler because now everything's electronic, I would think, right?
My understanding, based on the hearing record, is that Beth Israel has replaced its third-party vendor and has basically overhauled its system to
Right.
comply with the
So in the
Medicaid
going
regulations.
forward, this should not be a problem.
That's what we all
Hopefully.
hope, Your Honor.
Right.
Yes.
I'm sorry, I cut you off. What was your second point?
The final thing I'd like to address was that counsel had pointed out that Beth Israel produced a missing treatment plan a week before the hearing. Here, there was no legal error in the Department of Health adhering to its hearing appeal rules, which limit the appellant to matters raised in response to the draft audit report. Beth Israel did not raise this in response to the draft audit report and had more than 6 months to try to produce this document. And DOH therefore properly enforced its hearing rules in the administrative appeal rather than restarting the whole administrative process and requiring OMIG to reopen the audit, review the new evidence, redo its statistical analysis, issue a new draft audit report, and go through an entirely new hearing.
Right.
So
And the supplemental matters that were submitted did not address all of the issues that were raised, right?
That's correct,
So that
Your Honor.
even if you had agreed to engage in that process, it would not have resolved all of it.
no, it was limited to a single claim, Your Honor.
All right,
For all of those reasons, we urge the court to affirm the determination here.
thank you.
Your Honors, I just want to make clear, that single claim was worth $500,000. We're talking about an opiate treatment program here. At the end, and when the $7.7 million had to be paid back to OMIG, they had to shut one of the programs down. I mean, this is life and death. We're talking about people dying. $500,000 would have meant that we could have served hundreds, if not thousands of people.
Counsel, you can't put that on them, seeing as they made an offer to your client to settle this for just over $3 million instead of the $7.5 million, and it seems to me the same thing can be said for that.
So, Your Honor, when they offered for us to pay $3 million versus $7 million, they said you can provide these life-saving services to half your people or to none of your people. I mean, that's what our client was up against. $3 million would impact dramatically the program and the people that they could serve. And a comment was made that this is form over substance. That's what this is. This is not the mission of OMIG, is to stop fraud, to stop abuse, to stop people from harming patients. There is no indication whatsoever here that any patient was harmed whatsoever. Services were provided, excellent services were provided.
Counsel,
And now there
I'm
can't be.
sure that that's all true, but you know, and so I make sure your client knows. We are bound by a standard of review.
Correct.
And our hands are pretty tied on Article 78 cases, as I know you know. But I certainly appreciate the arguments that you're making and the life-saving work that is being attempted at this clinic. I want to make sure that they understand that is not lost on this.
No, I understand that, Your Honor. I mean, but the point I want to make here is that, there was certainly, there should have been substantial evidence produced by OMIG in this case, and there was literally no evidence. There was not much evidence to submit. It makes a farce of the hearing process. So you have a bunch of documents that are missing. These documents aren't even payable. They're not even something that's paid by OMIG to keep these documents. So you have these documents. Some are missing because we had a filing error, which we have corrected. So we have a filing error. So what ends up happening is, because there's a filing error, because these documents are missing, they take back $7.7 million from our program.
Well,
When we're able
let me
to
just
go-
say, it wasn't just that, right? The regulations require 3 signatures and a consent
there
form,
were-
right? And they found that there were several files that didn't have those required signatures,
And they
right?
were wrong
Correct?
about that, because the
Well, I mean,
signatures
we
were. Well, Your Honor, the
It's
reason
hard,
why-
I mean, that's what they found,
We
and
put
we're not going to
evidence-
go back and redo that hearing. But let's assume that that was a correct finding. That would disqualify that payment, correct?
That would if that were true, but we showed during the hearing that there were electronic signatures that they were not including. For example, they were not including the signatures by the doctors on the prescriptions. This is a program where what is happening to the patient is reflected in how they're getting medication to deal with their addiction.
See, but now you are saying, I know you have these rules that say that three people in the team have to sign off on the treatment plan, but you know what? If there's a signature on a prescription pad, that's enough.
Well, that's-
Now you are stretching these regulations beyond what was intended, and that is outside of the power of this court, I am afraid.
I'm afraid what they're...
Counsel,
Your
we're
Honor,
not going to continue this argument. I appreciate your argument, and we are out of time, and I thank you for your argument, and this court is going to consider the submissions on this case, I assure you.
Thank you, Your Honor.
Okay? Okay. CrowdPay versus StreamNet. You have 4 minutes and you may proceed.
Good afternoon, Your Honors. May I please the court? Leslie Forton from Forton Associates. I'm here for the appellant, StreamNet, Inc. I just have three quick points I'd like to make to start, and that is to say that the parties had a voluntary written contract. They agreed to arbitrate any dispute in the contract, and the lower court sent the parties to arbitration, and the power to vacate an arbitration award is limited. Furthermore, regarding the arbitrator's award, CrowdPay...
Is limited by what?
I'm sorry?
Is limited by what? You said arbitration award, the power to vacate is
Sure.
limited. Limited by what?
It's limited, well, it's limited by case law. For example, Wilco v. Swan and Shearson American Express.
You're not suggesting that this court doesn't have the power to review an arbitration award and determine if it's proper?
I'm sorry, I didn't hear you.
I said you're not suggesting that this court and that the court below did not have the power to review an arbitration award and determine whether it was proper.
I am implying that by
Courts review arbitration awards every day of the week in this state.
Oh,
So tell me why this particular arbitration is special.
Sure, thank you,
and
Your
is
Honor.
outside of that realm of review.
Yeah, what we're essentially arguing is that the arbitrator did not breach or commit a manifest disregard of the law in totality. That is to say, for example,
But who reviews that? It would be the court, no?
Yes, of course.
Okay, so then we're
Of
on
course,
the same
of course.
page.
Oh, we're
All
on the
right.
same page. Absolutely. And as stated, as an example, as stated by the arbitrator, he stated that it is undisputed that the agreement was terminated before any funds were released from escrow, nor were funds raised under a successor agreement with the provider unrelated to CrowdPay until an unrelated third agreement giving some funds were raised. And
But what is your argument with regard to the arbitrator's decision?
Yeah,
Vis-a-vis,
the argument is...
vis-a-vis the posture of this case.
Yeah, so what we're saying essentially is that the arbitrator reached a reasonable agreement or gave a reasonable award because he analyzed and construed the facts. And essentially what we're saying is that the law states that if in fact he didn't even want to review, for example, an anticipatory repudiation, and he refuted that, and he actually said that, look, I'm not even, well, first of all, as you know, he didn't find an anticipatory repudiation, but even if he said, and hopefully this is not stretching it, as to say, even if he said, I'm not even going to refute or even review the fact that there was an anticipatory repudiation in this case because there wasn't one, and we're also arguing that there wasn't one. But what we're essentially trying to put forth is that the arbitrator putting forth this award was reasonable. He reviewed the facts. He came to a reasonable conclusion. There's nothing outlandish about it. He put forth a reasonable analysis, and because of that, we don't think there was a manifest disregard of the law. We believe that in total, in a total conclusion, as to say, the conclusions that he reached were reasonable and justifiable with what was put forth to him in terms of the facts and the law in this particular case.
Okay, thank you.
Well, thank you.
May it please the court, James Klatsky for the plaintiff respondent. In the first case, what the court below held was that the two-page letter submitted by the defendant was not an unsworn statement that the court would not accept an opposition granted a motion on default. And if there's no appeal from a default, if it divests this court of jurisdiction, then the ball game is over here. But since the appellant has argued that that other provisions of Article 57 do give this court jurisdiction, then we'll address the merits of this case. Now, counsel's argument, we heard it. However, the court below was not preserved. The only thing that was stated in the letter was, in a two-page unsworn letter, was that the party signed an arbitration agreement, the arbitration was held, and so that was never in dispute. What the arbitrator did, in fact, was, he did, in fact, show manifest disregard of the law. The elements of manifest disregard are, one, that a governing principle of law is brought to his attention. That's not a dispute that it was brought to his attention. He stated that in his award. That he disregarded it, and the law is well-defined and clearly applicable. And the cases cited by brief, the courts have said anticipatory repudiation is a long establishment. Where he went off the rails was where he said that, granted, he sent him an email saying, stop doing the work, take down the website. But then he created out of whole cloth a new requirement stating that there's some requirement that the other party has to accept the repudiation. Right. And there is no such requirement, and he essentially created that out of whole cloth. Nobody can breach their agreement by saying the other side didn't accept the obligation. The bank that holds a mortgage on my home wouldn't accept that. And likewise, what the arbitrator said.
And all of these issues would be things that we might consider, but for the posture of this case, which is what we are deciding is whether the court properly granted the motion to vacate the arbitrary award on default.
Yes, but it's also a question that the appeal is not, there's no basis for the appeal on the merits, irrespective of whether the default was proper or improper. If this court were to find that he should have been given, that they should have taken that opposition, it did not address the question of anticipatory repudiation. That was not preserved for this court, and there was no anticipatory repudiation for the reasons set forth in my brief.
Right.
And if you have no further questions, I'll be seated.
Thank you.
Thank you.
Okay, you have 1 minute.
Well, I understand that my response to that is that essentially I think what the argument is that whether or not we are entitled to get this court's view. Am I correct? We believe that we are entitled to get this court's view on this matter because this court...
Well, counsel, do you agree that the court below issued the decision on default?
Yes, yeah.
Okay, so then what happens when a decision is issued on default? We don't have jurisdiction over that, right?
Yes.
What do you have to do?
I'm sorry? I'm just a little hard of hearing.
No, I'm saying to you that if if a decision is rendered on default, there's no appeal from that. There's a different procedure you have to follow, right?
Well, in some cases, yes, I understand that, Your Honor, but this court has, in Ream Construction v. Octal, this court found that, that case was examined by the court, for example, and the court denied defendant's letter motion to vacate an order, and this court reversed on the facts, and defendant's letter motion was granted, and the matter was remanded for determination on the merits. And we are only looking for a determination on the, to be sent down for determination on the, to be.
So then why don't you move to vacate your default?
Well, yeah, I understand.
And on that note, I thank you.
Well, thank you.
All right. People versus John Cabrera. You may proceed, counsel.
Thank you. May it please the court, I'm Joseph A. Bondi, B-O-N-D-Y, on behalf of Johan Cabrera. And Mr. Cabrera was subjected to what I submit was an unconstitutional inventory search. His vehicle was seized in the Bronx. He had been arrested on an I-card.
The car was impounded while they were doing their search, correct?
It was impounded. It could have been parked on the street, but instead it was brought to the precinct, impounded, and then a specially trained police officer who had been...
Does the intent of the searching officers matter if they are following established inventory procedures?
It could if the principal or goal of the search is to uncover contraband. But in this case,
So let's in that case,
yes.
if you had the officers here testify that, on cross-examination, for instance, that one of their goals was to find contraband, was to find maybe this gun that they thought the defendant had, would that invalidate an inventory, quote-unquote, inventory search that was being done pursuant to procedures?
Well, it could, and we're talking about multiple statements during the course of a suppression hearing where the officers conceded that indeed the thrust of their search was to look for contraband. They never created an inventory. They never identified a protocol. The protocol that the judge then relied upon was an outdated protocol. And I invite you to pages 33 and 34 of our opening brief, where I have quantified the record evidence of the officers stating that their aim was to find contraband. But they used a pry tool to open up the side panels of the vehicle.
That pry tool, the officer testified that he could have removed whatever it was, the grill, using his hands, but used the pry tool to minimize damage, which is required by the protocol. So I don't see anything wrong with that.
That's the old protocol. The new protocol is if it's a locked container, you need to go get a warrant, or you need
Well,
to
that's
get...
not a locked container. It's part of the vehicle, right? And if that panel seemed like it was protruding out from its normal placement, why is that problematic for them to then search it?
Well, first off, 2 out of the 3 officers said that the panel was flush, the speaker cabinet was flush in the center console. Second off, the officers went through the side door panels with that spoon prior to looking on the dashboard in the cabinet, and this is the taint.
So that you're saying that they had been using this tool in other areas where they didn't identify it as not flush, and therefore that statement is a pretextual statement.
This is all a pretext. This is disingenuous. But and I cited in the brief, and there's video evidence of this, oddly enough, but not the search of the cabinet, going through the side panels with a spoon tool. And I was thinking about how to analogize this, and I almost brought you a spatula from my kitchen that I used to open up my son's dresser drawer the other day because the handles had fallen off.
You got a search warrant for that?
I should have. And then I thought about a paint can and a screwdriver. And in our reply brief, I talk about the law of the lever and using a fulcrum. You can use a tool, and it might not seem like you're applying that much physical force, but indeed you're applying a significant amount of force. I see my time's run, but I'll say this cannot possibly be the state of an inventory search in New York, where there's no inventory, there's no reliance on protocol.
Does the fact that their testimony provided us with the information that would have been included in a inventory form suffice?
No, not at all. You look at Johnson and all the cases interpreting GALAC, you need to have record evidence of there being a protocol, and you need to have the inventory. That's the basis, the gravamen of an inventory search.
So wait, are you saying you have to have a written inventory list as a matter of law? If there's no written inventory list, that it automatically means suppression?
Within the square of every case, yes, there are some outlying instances where maybe you could have an oral inventory, but here there wasn't even one.
Well,
There
I
was
thought
only-
I thought the testimony, and correct me if I'm wrong, was that the officer, when he was doing what he was doing, he turned on his body camera to sort of take an inventory. Instead of having a written inventory, he had a video inventory of what was going on.
Well, Your Honor, they had a camera view of the side panels being opened, but for some odd reason thereafter, when they went into the cabinet, they had to return on the body cameras. And you wouldn't know if there was a sweater seized, a piece of property seized.
No, but I'm just at, well, I want to just focus you on whether you think that the video of what they inventoried is sufficient, because I just heard you say, no, it has to be a written list. But what I want to know is, do you believe, regardless of whether you think they did a video of what they saw and inventoried would be sufficient?
First off, the video wasn't continuous in this case. There were gaps, number one.
I'm just asking you, yes, but assume that all of that is true. Assume that it was continuous or that it did list the items. Are you
Maybe if the video had been vouchered for the purpose of an inventory, which is what they were allegedly doing, it could have been, but that wasn't what happened here. And we have no way of knowing the other things of Mr. Cabrera's that were in that vehicle. And what's the purpose? To protect his property, the police against a claim of some kind of theft or
Counsel, besides the gun, was anything else vouched by the police in this?
nothing whatsoever. A cannabis joint, a cannabis roach was vouchered, and the firearm. That was it.
Was there anything else allegedly found?
There was, they couldn't say. The officers they had no record of
Because
anything.
they typically only inventory something that would be of value, so that something that someone might later say, these items are missing from my car. I had a camera, I had a phone, whatever.
Well, two things. There was no statement in the inventory that there was nothing of value seized.
Okay.
And again, what possible property of Mr. Cabrera's were they looking for inside of like a side panel to the door, right? Or a factory-issued speaker cabinet? Thank you.
Okay, thank you. All right.
Good afternoon, Your Honors. May it please the court. Elliot Robert Hamilton for the Office of the Bronx District Attorney. Your Honors, the suppression...
If we believe that the officers here conducted this search with the goal of looking for that gun under the premise of an inventory search, would that be proper?
Well, Your Honor, People v. Lee, which is 29 New York 3rd, 1119, stated that that an inventory search would not necessarily be invalidated if there was that the officers knew or suspected or believed that there might be contraband.
No, that's not the question. Not suspected or knew.
Repeat the question.
But looking for a gun.
I think if they were looking, so the issue in that, so the court credited the testimony of the officers in that.
I really need you to, because otherwise we're going to be here a long time, okay? Because this is a serious issue. And so we need forthright responses.
Of course, Your Honor.
Okay? So let's try it again.
Repeat the question again, sorry, Your Honor.
I think where you were going was that the court credited the testimony of the officers that it was an inventory search.
Correct.
But if you took a close look at the record, on cross-examination, both officers admitted that they were looking for contraband.
So
is that a death blow to your argument that this was an inventory search?
I would say that...
And I'll add to Justice Rodriguez's point, not only on cross, but on direct, to the question, so answer my question, my last point, officer, can you describe what led up to this picture being taken? Can you describe your search of this car? Answer, yes. So we were just searching the vehicle, checking every place, you know, obviously where contraband could be hidden. And in that front speaker, you could just lift it up with your fingers and it would be pop open. So you got this direct and you got the cross. Well, we got a problem here, don't you think?
Well, Your Honor...
This car's impounded. It's just sitting there.
Well, Your Honor, I would concede that absent any testimony, any specific testimony about them following the procedures to a letter, and them saying that that they may have been rummaging around, or they.
Counsel, my question is not about procedure. We're not there yet. That may be a secondary problem for you. Before we get there, the question that I'm asking you is, if this is a pretext, if you're saying I'm doing an inventory search, but really your goal is to find that gun that the detective said he had, is that a problem?
I would say that would be a problem in a situation like that, Your Honors. But our position is that that despite the cross-examination of the officers, as well as and with that taking into account, plus the testimony of the defense witness, that the court found that the officers' testimony was credible, that they were going through an inventory search, and that they were.
So we're supposed to believe that the court credited the officer's statements that is an inventory search, but did not credit their statements that they were looking for contraband.
I think the court was able to distinguish the answers on cross-examination. I think that this court generally tends to give deference to the suppression court judge when it comes to the.
Our deference is not absolute, and our deference
I can see that, Your Honor.
our deference is bound by the law.
I can see that point. Your
Nothing
Honor.
else. By the law. So the court can't say, as my colleague just said, I credit this part of their testimony while they ignore the other part of their testimony where they admit they're looking for contraband. And since the car is impounded, there was nothing to prevent the police department and the district attorney's office from getting a search warrant for a car that wasn't going anywhere.
Point taken, Your Honor. And could in the hypothetical, could a warrant have gotten in that circumstance? Sure.
Unfortunately, the question is not could, it's should have a warrant been obtained.
We've interrupted you, so I'm going to give you some time if there's anything else you wish to say. I don't want to be accused of having shortchanged you of an opportunity to convince this court.
Well, Your Honor, the other thing, to that point as well, I would say that the suppression court did and ultimately find that the people met the burden of going forward, and defendant did not meet their burden. Didn't meet their burden to say that the evidence should have been, and that the way that the evidence was obtained was bad. There were opportunities. I would submit that defense could have cross-examined the officers about other property that was taken in the furtherance of an inventory search if there was.
But it's not his obligation to meet your burden. It's the people's obligation to show that what happened was proper. He didn't have to ask questions to help the people make out their burden.
I'm not saying that, Your Honor. I'm saying that while
you said, he could have asked questions.
I'm saying
he could have asked questions about what other items
they
were
could.
inventoried.
My position is that defense did not meet its burden. Did not meet its burden. That's not the same as us trying to shift our burden. That's not what we're saying at all, Your Honors.
Okay.
I apologize if that's what
not
you
a problem.
Thank you.
You realize this is a tit for tat. This ain't personal.
No, I understand.
Okay.
We ask that you affirm the judgment.
Thank you.
Thank you very much. Warrants are required except in narrowly circumscribed exceptions. And if you look at the law in New York State, it could be a regulatory inspection of a closely regulated industry like the Court of Appeals reviewed in June in Owners and Operators versus Department of Transportation. It could be here. But the basis
Let
for
me
the-
just ask you, do you agree that if the officers are doing an inventory search, that it's also okay for them to look for contraband, or they can only look for inventory?
Sure, and that's what the cases say, is that you can find
If the court credits that they were doing an inventory search by their testimony, but they said, but sure, we're also looking for contraband, that's not a problem.
It depends. but generally the cases have supported that. Nonetheless, there's no evidence here of the protocol. And what the protocol does is it provides that guardrail, right? It provides a guardrail to bar the police from acting in an unconstitutional manner. And
Does the fact that your client, when the police stopped him and asked him to get out of the car, refused and had to be physically forced out of the car, did that add anything to this in light of the I-card they had?
No, they knew where he lived. They found him. He had an I-card. He was subject to arrest anyway, period, end of subject. But without that warrant, there has to be the protocol, because that's the constitutional safeguard against unfettered discretion by the police officer. There's nothing in the police protocol about I'll bring a spoon tool or an upholstery tool, or I'll kind of jimmy certain things open with force.
Counsel, what's your main argument? Is your main argument that what happened here was a pretext to search for that gun, or is your main argument that they didn't establish the inventory protocol?
Good question. It's a pretext. There was also insufficient evidence of there being reliance upon the then valid current protocol in place. And furthermore, I could...
Twofold, basically, your argument.
Yeah, twofold. And the thing is this, if you think about pry tools and force, if I got locked out of my home today and the deadbolt wasn't locked, I could probably use a credit card to jimmy my way back in. And I mean, the door's locked. That's a pry tool, right? If you're trying to open the can of nuts in your kitchen and you can't open it and you slam, 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 I mean, maybe you can use the pry tool to open it. But you're still using a certain quantum of force, and it's that force that was not permitted under current protocol. And by the way, the court, in rendering its decision from the bench, relied upon an outdated protocol, almost verbatim.
Okay.
Thank you very much, Your Honors. Thank you.
And I'm glad we took the argument.
I'm so glad, and I'm so sorry. I really thought it was 2:30 for vision.
2 o'clock, remember that.
I will
Thank
always
you.
remember. Thank you.
All right.
Thank you.
You won't forget now.
All right, Torres Cuito versus 1711 LLC et al. Yes. Camp out where you can, okay? All right. You may proceed, ma'am.
Good afternoon. May it please the court. Christina Mercado with Block, O'Toole, and Murphy for the plaintiff, appellant, respondent. The lower court erred when it held that a
Okay, now I have a quick question.
Go ahead.
Was there a brick or was there not a brick?
There was a brick. There is no.
Nobody's disputing that there was a brick.
There was a brick. Whether it was a piece of brick, there was a brick.
I just want to know if there was a brick, because everyone's, the way it's set up is like they're all
I mean, in
dancing
fact,
around.
I'll just
we
jump right
have,
ahead.
we have stuff in the record that there's a report that says a brick.
There's,
and then there are other people saying there was not a brick. There was no evidence of a brick.
There was evidence of a brick. Besides the rider accident report, page 1511 in the record, is, besides a business record, an admission by rider that the plaintiff was receiving a delivery in front of the hoist area when his hard hat was struck by a piece of brick.
And that hard hat cracked.
And the hard hat cracked. The lower court erred when it held that 22-story height elevation differential could be de minimis under Labor Law 240, or that a brick that cracked a hard hat could be incapable of generating any meaningful amount of force. As I said in the papers, the court only relied on the Peters case, which involved a 5-millimeter piece of debris.
Wait. What did plaintiff testify to? He said he didn't know what hit him, right?
No. Plaintiff testified he did not see.
He didn't see what hit him.
Right. Anytime a plaintiff is hit on the head with something,
Oh,
they
of course.
don't see it.
But then he said, my friend Mr. Doyle told me I was hit by a brick.
What plaintiff said was that he felt it. No. What plaintiff said is that he.
I
felt
read
a
the
strong-
deposition testimony. I should have brought it.
He also testified that, but that testimony is.
And then Mr. Doyle said, I didn't see any brick, and I didn't say that to plaintiff.
Well, here's the testimony that's consistent with Mariquin, Garcia, Mercado, Pados. Plaintiff felt it on his head.
Let me just. I'm not here to decide whose testimony is right or wrong. I'm
It's not a
asking
credibility
you,
issue.
If the plaintiff said I didn't know, and this guy told me this is what happened, and the guy says no, I didn't, how is that not a credibility issue?
Because that's not what happened in this case. In this case, the plaintiff felt something hit his hard hat. It was a strong blow. It cracked his hard hat. He immediately looks down and he sees a piece of brick. That's an observation. We don't need hearsay. He looks up and he sees a hanging scaffold, workers 22 stories up, chipping into the brick. That's all we need. That coworker that testified, yeah, he testified, the truck driver. I stayed in the truck the whole time. I didn't actually see something fall, but immediately after, all the coworkers are running up to me saying, Johnny got hit, Johnny got hit. I see his cracked hard hat.
And he confirms that coworkers said to him that Johnny got hit by a brick. He confirms that in his own testimony. I have it in front of me.
Doyle, yes. Doyle says
It's not a bad thing, you know.
No, I'm just trying to figure out, did he say, did your client not say that Doyle told him it was a brick?
Doyle said it was that brick, but later in his testimony he said, I don't know if he actually saw the brick that fell, which is always true. You never know if somebody saw it. That you don't have personal
But Doyle
knowledge.
never said he didn't get hit by a brick.
Right.
Correct. Doyle never said he didn't get hit by a brick. All of the other coworkers come in immediately after saying, Johnny got hit.
Is there other testimony from other coworkers who say, yes, we saw the brick hit him?
No one saw the brick hit him, just like in Mayor Quinn, Garcia,
No,
Mercado,
I'm just asking you,
Addo.
so when you're saying all the other employees come in and say, yes, you got hit by a brick, that's not right.
Is the issue
They
whether
saw
you
that the
saw...
accident happened.
Look, I don't think anybody, unless you're Superman, is going to be able to say they saw a brick falling from a 22-story scaffold. So let's dispense with that red herring. Nobody saw it. It hit his helmet and it cracked his construction hat.
Correct.
There's no issue about that. Am I correct? Did
That's
anyone
correct.
say that's not true? The construction hat wasn't cracked?
Nope, there's a
Okay.
photo of it,
And
actually.
didn't, as my colleague said, the Ryder incident reports say John Torres was receiving a delivery in front of the hoist area when his hard hat was struck by a piece of brick.
Correct.
Okay. Is there any report that contradicts this?
No.
Okay. There was also a incident report by
The site safety.
the site safety, and that report said was wearing hard hat and struck by debris, parentheses, brick. This associated with cleaning of the easy scale scaffold. Large pieces should have been removed by hand rather than swept. Is that what the reports say?
That's correct, Your Honor.
Does anything contradict that?
No, there is no evidence contradicting that.
Okay.
It is also undisputed that there was no overhead protection in this area, that there was supposed to be. The defendant GC witness testified that there should not have been delivery going on in this area when any overhead work was going on. In fact, he said OSHA and the Department of Buildings require that there not be the work where plaintiff was.
And they have basically blocked off the right-hand lane of travel.
Correct.
On First Avenue, I believe.
Correct.
Correct? In order for big trucks to deliver items.
Correct.
But there was an area set up within the construction site that was under netting that would have been a safer place to do this.
Yes, there were other places. There was sidewalk bridge somewhere else, and there could have been overhead protection here.
And the other thing was there was testimony in the record with regard to this brick. The brick being used on this facade was the same brick being used on the whole building, right?
That's correct, Your
And
Honor.
that brick was red on the inside and either baked or painted with a white covering on the outside.
That's correct, Your Honor.
And the people who were at the site after the accident described the brick as being red on the inside with a white covering on the outside. Right?
Correct, Your Honor.
All indications that this brick somehow fell off the building.
Correct. That includes defendant Ryder's witness Vita admitting that it was the photo piece of the brick is consistent with the facade of the building 2128 of the record.
And that's the GC, right?
That's the GC.
Okay, thank you. You'll have time on rebuttal.
If there's any further questions, okay.
That's a wrap.
You'll have time on rebuttal. Who's next? You have 3 minutes.
May it please the court, Your Honor, Marion Hyatt with Fuchs Rosenzweig for defendants, appellants Ryder and 1711. With regards to 241.6 and 200, I just want to dispense with that. Plaintiff did not oppose those portions of our motion. We request they be granted. With regard to 240, we assert that plaintiff is essentially making a res ipsa argument here, that something fell and
Sorry,
hit
say
him.
what
A
did you
res ipsa argument here, that something fell and hit him. He doesn't know where it
Isn't
came
most
from.
falling objects a res ipsa thing? I mean, if
Usually you
think
can
about it.
identify where something came from or who was responsible for it.
Now, if you get hit and you get knocked out, you're not going to know where it came. All you know is you're on the ground and you're knocked out. So how are you going to do a res ipsa? He's on the ground. He's out cold.
But there's
In this
obviously
case,
other
he got his
people.
helmet cracked.
I understand his helmet was cracked, so we're not disputing something must have
Let
hit
me
him.
ask you, are you disputing that a brick hit him?
We don't know what hit him, honestly. Yes, we are disputing that.
What about the
Where in the
records?
papers do you dispute that a brick hit him?
We are saying that plaintiff was never able to identify what hit him. There's no witness that says what hit him, and he's relying on shards that he found around him being what hit him.
No, but what about the documents that
Well,
that
we're
my
relying on the
colleague
plaintiff's own
read?
statements for those documents. It's not that.
Okay, but they're business records, right? If there was, they're your business records. So you're saying your own business records are lies?
Not that they're lies, but we're relying on what's being told to us. By the
Especially, look, Ryder went out of its way in its incident report, okay, to point the finger quickly away from them, okay? It was in your report that you said a brick fell on him, and then you quickly pointed to Bunlin, who was doing slab edge waterproofing work, and Pioneer, who was installing the windows. So, I mean, it's really incredible to have you come in here now and make this argument.
Well, I
in
mean,
light of this document.
If that is the work that was being performed at the time, then that's obviously the only place that we could attribute where this brick possibly could have come from. But there was nothing wrong with the facade. No one pointed to any broken bricks in the facade where it could have come from.
They had broken the bricks in order to put in installation of windows. That's how windows are put in.
I understand that, but that is not what VNP is saying that they were doing when they were installing the fins. They indicated that there was no brick was damaged in the way that they were installing the fins.
They also said that they had to chip away at any debris and sweep it away so that the window could be inserted in a flush space.
Yes, and
in fact, that is precisely what the reports indicate, that it should not have been swept out.
Well, there was netting around the scaffold where they were, and where their
Not
work was
where the
performed.
plaintiff was standing,
No,
there
not where the
wasn't.
plaintiff was, but
So
their
that
work-
netting is irrelevant.
Well, their work is 6 inches from the facade, where the plaintiff was is 45 feet from the facade. So there's multiple layers of protective devices before you
And
get
yet
to that
something
area.
fell on his head and broke his construction hat.
Something, but we affirm that there is nothing that, no testimony that can say that it came from
You're
this
going
construction
against your
site.
own reports. How
Yeah.
do you do that? I mean, I'm sitting here listening to your argument. You're basically saying you're challenging your own reports, which is a business document. How do you do that? How do you put something down on a report saying it's a brick, and then now stand here and say, well, we don't know what hit him?
Because we're taking, obviously, when we're doing the report, we're interviewing the plaintiff, asking what happened, and that is the information that he is providing to to us. That's not coming from firsthand knowledge from someone from Ryder that a brick hit him. That's coming from the plaintiff's
And how do
version of events.
this case just came out today that we just published, Harsani, where the person got hit in the head also. And it's like, you know what? How that person got hit is not relevant to the discussion. All we know is he got hit in the head. How do you address that? I mean, think about it. I mean, well, I just popped that up on you, sorry.
Okay, anyway, thank you. Next. I don't know the order, so
That's okay. I'm PI Mechanical. I'm plaintiff's employer.
you have 4.
Okay, thank you. So I'm just going to do quickly 240 and then back to the contractual indemnity, which is important for us. I'm going to assume that the brick came from the project, right? I'm going to assume that the brick hit plaintiff, right, for the purposes of the argument. We still don't know, under Peters, from this case in 2022, the weight of the brick, the size of the brick, or how far it fell.
It doesn't matter. It cracked his construction hat. If he didn't have a hat on and you had a recalcitrant worker,
Sure.
you would have a dead man on the floor.
Sure.
Okay?
Right.
So, what difference does it make?
Because it's circumstantial evidence versus direct evidence.
I think the circumstantial evidence of the cracked construction hat speaks volumes.
Okay. I understand. So I'm going to go to the contractual indemnity argument then. I signed a contract with 1711 and Ryder, I'm plaintiff's employer, saying I'll indemnify you for all work that arises out of the performance of my work, right? Active.
Yeah, but he was performing your work. He was removing stuff out of the truck or something
Yes,
when he
but
got hit in the head.
But the DeGidio case from 2019 of this court, which I will give the site to, is 176 83rd 452. Plaintiff was injured in a crane collapse, okay? He was a subcontractor. He had his materials on the crane. The crane collapsed, he got injured. This court said, simply because plaintiff was injured due to the work of another contractor who was responsible for the maintenance and operation of the crane, and that plaintiff was injured, is too tenuous of a connection for the arising out of trigger.
But you've made a tenuous connection. There's no tenuous connection, unless I'm totally missing something. This guy is your employee.
Yes.
So that there's no tenuous sub or whatever, sub involved. He was your employee, and he got hurt doing your job.
Right, but arising out of is a causal relationship, though. There's a little bit more than alleged or claimed to arise out of the work.
They're taking a delivery off of your truck.
Well, think about it this, and I guess...
I've been thinking about it. I've been
Well,
losing
I'm thinking
sleep
about it in
over
a
it,
common,
too.
like a common sense standpoint. I'm signing the
Oh,
agreement
don't
with
talk about common
1711
sense
and
when
Ryder.
you talk about labor law.
Well,
Way
that's
off
fair.
the mark,
That's
yeah.
fair. But I'm signing an agreement, right, to indemnify 1711 and Ryder. Bunlin, VMP, and Ryder, they're the ones who did the work. They're the ones who were negligent. I'm sitting there
They're
unloading
coming
brick.
up next, too. Don't worry. We got.
But that's not the issue. The issue is what the agreements say in terms of of the indemnification. So why don't you focus on the language of your provision and tell me why that language would take you out?
I would say, based on this court's decision in DeGidio, okay, which I
asked you to tell me what language in your provision takes you out.
It says-
and you're going to cite a case to me.
It says performance of the work, okay? My work had nothing to do with the brick falling on plaintiff. My work was HVAC work, street level and inside the building. VMP installed the windows. Bunlin installed the bricks. Ryder decided, well, maybe no overhead protection, maybe we'll allow people into the thing.
That kind of argument means that you're telling me that indemnification clause, you're reading it so that it has to be, if that accident resulted from something other than performing the work, I don't need to provide indemnification. That's what you're saying, because you're saying that.
We've held indemnification for workers who are walking up to their job site.
I know.
Okay, so
Yeah.
I don't understand this argument, honestly. Whether he was doing the work that was HVAC related or got reassigned at the moment to help unload this truck is irrelevant.
I'll just go back to the cases out of my brief, Honor, that some go in the other direction, and I would hope you could read them. Thank you so much.
Okay.
Have a good day.
I love these cases.
Next.
Get you going.
Who's next?
Who's next?
Well, you both have three, so it doesn't matter. Proceed.
Who's still on the?
And remind us who you're here for.
Still on the appellants?
Hey, please, Court, Your Honor. My name's Andrew Weiss, and we represent CNR Safety, which is the safety contractor. We respectfully submit to the court that our motion for summary judgment, which should have gotten us out of this case, was wrongly decided, and it should have been granted.
Okay.
Obviously, because if it was granted, we wouldn't be standing here today. Basically, we make three arguments, which is that, number one, that CNR Safety is not liable for negligence because that wasn't their negligence of another person or another entity because that wasn't their job. Under the New York City building
There's
code,
no evidence that it's CSRG, right? I want to make sure I don't mess it
I
up.
call them CNR Safety. You can call them whatever you want.
Okay. That they in any way controlled the manner of work of any of the people that they oversaw.
That's correct, Your Honor, and that's precisely where I was heading with my argument, citing both the Martinez and the Smith cases, where there was nothing in the record, there was no evidence showing that they did anything other than act as a Section 33, basically safety consultant, where their job was to come up with a safety plan, observe, and report, and that's it.
Right.
And that's what they did. So anything beyond that, they had no power to issue stop work orders. There's nothing in the record to show that they did actually issue stop work orders. There's nothing in the record to show that they exceeded either Section 33 or their contract, which basically says observe and report. That's what they did, and therefore they would not be liable for the negligence of another party. There's also no common law indemnification for the same reason, because they didn't do anything negligent. They observed, they report. That's their job, that's what they did, and there's nothing in the record to say otherwise.
And there's no evidence in the record that there was any report to them that, that the workers on the 22nd floor who were doing the window work were doing anything that posed any major hazard that would have required your client to act.
Actually, no, there is no requirement for my client to act, because my client...
No, that was a friendly question. I don't think you heard the first part, so let me try it again.
I'll take the friendly one, thank you.
I said, there was no evidence in the record that CSRG was notified that someone on the 22nd floor was doing something dangerous that would have required them to act. There was nothing.
I am not aware of that, Your Honor.
Okay.
And again, there would be no breach of contract, which would be the third way that you would try to bring them in, because if they didn't do anything negligent, then they didn't breach the contract. Right. And as this panel clearly knows, because this is not the first labor law case that's been argued before you all.
Right.
It won't be the last.
Sorry. Liability runs from the owner through the general contractor down to the sub, et cetera.
Right.
We're not part of that chain.
Right.
So therefore, we would.
I mean, there could be liability for a safety consultant, but you're saying in this case there are no facts that would warrant that.
That's correct, Your Honor. And to say otherwise would be purely speculative. And as Your Honor knows, speculation is not the basis for creating a question of fact and denying a summary
Absolutely
judgment
not.
motion.
Thank you.
Thank you.
All right. You got 3 minutes.
May it please the court, Your Honor. Abe Reichert, Katz and Reichert for Pioneer Window Manufacturing Corporation. We have a broad indemnity agreement. The lower court erred clearly. It does not have to be a finding of negligence or proximate cause relating to just a claim. A claim here has been made, has been lodged. The evidence indicates that V&P was performing this work. They had a scaffold. They're using, as Your Honor said earlier, hammer drills, knocking into the side of the building, and this thing comes down. This is exactly why we have this indemnification provision. It's broad. It doesn't have to have a finding of liability or negligence. We didn't do any work there. It should be overturned.
Thank you. All right. Plaintiff, you've got 2 minutes.
If the court has no questions, I'm not going to touch 240. Just if the court does not reverse to grant plaintiff 240, we do oppose the negligence 200 claims against Ryder and the 241-6 claims. It's page 23 of our reply brief. So.
That's it. Thank you.
Thank you.
All right. People versus Carl Johnson. Give me 1 moment.
Good afternoon, Your Honor.
Give me 1 second. Let me put the clock. Go ahead. You may proceed.
I'm Catherine Martone on behalf of Mr. Johnson. The SORA hearing court erred here in departing upward based on the purported aggravating factors that Mr. Johnson has New Jersey felony convictions and the circumstances of the offense. As to the first factor, the prosecutor at the hearing conceded that the record does not establish that the New Jersey convictions qualify as felony convictions. Based on that conceded fact, the hearing court properly disallowed the points the RAI, the risk assessment instrument, assigned under factors 9 and 10 for having a recent felony conviction. The court erred in failing to recognize that the same conceded lack of proof precluded relying on the convictions as felonies to justify upward departure. As to the second factor, the court cited the manner in which Mr. Johnson committed the first-degree sexual abuse. That is, while being naked in a public place. The court called that conduct disturbing.
But it wasn't just him being naked from the waist down in a particular posture, let's say. But it was that he then knocked the woman down and proceeded to hump on her through her clothes in the middle of 34th Street, I believe, at 1:50 in the afternoon. I can't think of anything more frightening for somebody walking down the street and all of a sudden you're knocked down to the ground and you have some stranger humping on you.
Yes. You know,
And others had to take him off of her. So I don't think the judge was wrong in saying that this was highly disturbing,
yes.
right?
But the circumstances are already taken into account in the RAI, in the risk assessment instrument. For instance, whether or not force is used. So what the court can't do, and of course, Your Honor, any first-degree sex abuse incident is horrible for the complaining witness. But here, the fact that it happened in public and Mr. Johnson's being naked, the court would have to find, based upon clear and convincing evidence, that those facts were probative of an increased risk that he would commit another sex crime.
So isn't the fact that he has all those New Jersey convictions something that the court is entitled to take a look at to see whether or not this particular RAI accurately reflects this defendant's risk level?
The court could only make a determination based on the record, and it could only depart upward based upon clear and convincing.
Right, so there's clear and convincing evidence. You're not disputing that he had all these New Jersey convictions,
He had convictions. What I am disputing.
and one of them was like pretty close to this conviction.
I'm sorry, Judge.
What I'm just saying to you is you're saying that the court couldn't take that into account?
It could.
And it did, right?
No, well, he took it, he could take into account what was proven. What was proven was that he had New Jersey convictions.
Right.
Under the RAI, he could have assigned 5 points for Mr. Johnson having a criminal history. It was not established that that criminal history constituted for a sex offense or that it constituted for a felony. So the court could take the criminal history into account.
I'm sorry, let me just read to you from his decision. Treating this defendant as someone who has no felony convictions at all, in particular since he does have several felony convictions and at least one within less than 3 years of this offense. So it does seem like the trial court did take a look at the convictions he had. He said they aren't adequately taken into account by the RAI, and then moved him up to a level 2.
And that's the heart of the error right there, Your
Why
Honor.
is that an error?
Because it was not established that those convictions qualified. They were New Jersey convictions, and the court couldn't count them as felonies.
For sure, under the RAI, but he's entitled to look at them outside of the whole totality of the record, correct?
No, because they weren't established to be felonies.
But didn't he rest his decision not on the felony convictions, but on the disturbing nature of this case, right?
It was both factors, Judge. It was both factors. And as I was saying, the disturbing nature of this case, to rest on that, would have to have some causal relationship to a risk of recidivism for a sex crime for this defendant. And here the record shows that at the time, Mr. Johnson was severely mentally ill. He was actually, within 2 weeks of the incident, determined unfit to proceed to trial. and was committed to Mid-Hudson Forensic Psychiatric Center for treatment. The records relating to his commitment show that he responded well to the medication that was prescribed to him and to the treatment, which included therapy and counseling.
I've got to tell you that.
Judge, it's very...
I can only, as I read this case, I thought, okay, he's got a history of schizophrenia. This is what he did. He was clearly off his meds.
Well,
or had to have been off his meds.
Or maybe hadn't been prescribed meds yet. You know, we don't know.
Right, so he wasn't taking medication.
He needed meds.
Okay, but I don't, schizophrenia is not something that happens, typically from here to tomorrow, from one day to the next. There's a history for him, so that he has to have some responsibility for maintaining his own mental health, especially if coming off medication, this is how he decompensates and declines, right?
But he has no history of ever having committed a sex offense. And there has to be the relationship between having schizophrenia and being more likely to commit another sex offense. Your Honor, if there were that kind of empirical proof, that kind of research, suffering from a mental illness would be one of the categories on the RAI, like use of drugs or alcohol, if it predisposed you, was a good predictor to whether you're going to commit a sex offense.
Now, before you sit down, I want to ask you something. You said that the court could have, without proof from the people of the underlyings, could have assigned him 5 points, right?
Right.
And based on my math, had he done that, we wouldn't be having this conversation because he'd be a 75 and thus a level 2, correct?
I think he would be 60, Judge, according
That I added wrong. Never mind. I'll hear from the people.
Good afternoon. May it please the court. Megan McLaughlin for the people.
Counsel, how do you respond to your adversary's position that the convictions from New Jersey and the fact that he suffers from schizophrenia doesn't have a causal relationship to his risk to reoffend?
So I'll quickly address the mental health issues. The people never claimed that that was an aggravating circumstance in this case. In the people's brief, we simply rebutted defendants' claim that that was a mitigating factor.
So let's put that to the side. Address the New Jersey convictions.
Yes, so the New Jersey convictions, I think that we're beside the point here in discussing whether points could have been assessed or not. It's the people's position that the points could have been assessed against defendant, especially given that the board is entitled to look into the underlying conduct of and the board, by the way.
It's hard for you to come in here and make that argument when your people conceded at the hearing, right? They didn't have the evidence that was required in order for the court to make the assessment. And now you want to somehow say, oh, it doesn't matter. It does matter.
Yes, Your Honor, that's completely correct. The people conceded that because of the timing of the hearing that we had.
So that ship has sailed.
Yes. So I think the crux of the issue is that regardless of whether the court could have assessed points for these 4 felony convictions, the court did not. It erred on the side of caution.
Right, but in not assessing points, what the court did do is it considered those convictions for an upward departure.
Yes, Your Honor.
And my question is, was that appropriate given that none of the New Jersey convictions, as counsel argues, would provide any insight as to this defendant's probability or likelihood of recidivating?
Because, Your Honor, the board is very clear in its guidelines, and specifically the explanations behind Factor 9 and 10, that a criminal history of any kind is indicative of recidivism. And here, as counsel...
The analysis is whether or not the Soros court abused its discretion.
I'm sorry.
The analysis becomes then the standard review is whether or not the Soros court abused its discretion in considering those felonies, right, in terms of doing the upward departure.
Well, the court weighed the aggravating factors, which were 4 felony convictions and the disturbing nature of the crime, as this court has already discussed.
So you're saying those two things together gave, the courts using those two things together to raise up to a level 2 was not an abuse of discretion?
Yes, Your Honor, especially given, as this court already pointed out, in the alternative sense, the court's just ignoring these 4 felony convictions when the board has specifically delineated convictions of any kind, specifically felony and violent convictions, as specifically being related to recidivism. It wouldn't have made sense for the court to just disregard these convictions altogether. It made perfect sense for the court when presented with a situation where the conduct fell outside of the 4 corners of the points assessment box to recognize them as an aggravating factor nonetheless, and very appropriately upwardly departed back to the board's recommendation of a level 2.
Thank you.
Thank you.
So it seems like the SORA court didn't assess the 25 points because it knew that the evidentiary support there wasn't there to assess the 25s. So he did the default thing about, okay, but I still can't consider them as aggravating factors, and it goes down to now it becomes an abuse of discretion analysis that we have to apply.
Yes, because the courts, without the authority, it cannot upwardly depart based upon that rely on that as an aggravating factor, because the same standard of proof applies. See, when the court recognized that it couldn't count them under the RAI, that was because they weren't proven.
Right.
And it couldn't rely on them as felonies as an aggravating factor because the same standard of proof applies.
I'm not so, okay, I'll have to look at that, but I'm not so sure about that, but okay.
That's exactly the problem.
Because otherwise it wouldn't be an abuse of discretion analysis then, right? But based on what you're saying, if the court cannot do X, Y, and Z, then
it couldn't do.
then why are we looking at it as an abuse of discretion?
Well, then I shouldn't have agreed with you that it constitutes an abuse of
Okay,
discretion because it lacked the authority, Your Honor, to rely on a fact that wasn't proven by the same standard of proof. So the court wasn't allowed to kind of do this backdoor fact finding where the proof, it wasn't met, the prosecution didn't meet its burden here, right? And then just rely on it over here based on something less. Departing upward is a severe thing for the defendant. It takes him from a level 1 to a level 2. The same standard of proof applies to the court's fact finding when it's deciding to depart upward. It says as a significant thing as assigning points under the RAI.
Thank you so much. NGM Management versus Bear Burger Group.
Good afternoon, Your Honors. May it please the court. My name is Paul Pagano. I represent the appellants in this matter. Appellant's appeal is essentially broken down into 2 components, those dealing with the appellant's counterclaims and those dealing with the causes of action with respect to the respondents. The appellant's counterclaims deal with very straightforward breaches of the subject agreements here, which are the franchise agreements. The first counterclaim that I'm going to discuss deals with the statement that or the obligation that you cannot challenge the validity of the franchisor's trademarks. It says it very clearly in the franchise agreements in black and white. The validity of the franchisor's trademarks have been challenged again and again and again in effectively every pleading that's been before this court. I'm sorry, that was been before the lower court. The respondent's argument on that front is we weren't really challenging the trademark's validity. Stavroulakis was challenging it. Stavroulakis didn't file any of the pleadings. The respondents filed the pleadings. Even if you were to credit them with, even if you were to give them credit that Stavroulakis was the impetus for it, the respondents were still provided with a settlement agreement which showed indisputably that Bear Burger Group owned the franchise, owned the trademarks, and they continued to dispute it after that point. The respondents also claim that the no challenge provision is invalid. We provided the court with authority, including Capri Sun, which shows that the no challenge provision is in fact valid as upheld in that case. The second counterclaim deals with royalties and brand development fees. 5% of the gross wages with respect to royalties, 1% with respect to brand development fees. I don't ask you to take any of my clients' word on this issue. I ask you to just look at their expert and say what their expert has said. Their expert has made it clear that there was a $61,000 shortfall with respect to the royalties. There can be no question of fact with respect to the fact that royalties and brand development fees were due.
But what happens if we find that you breached that agreement first? Then what?
I don't believe there was any breach of that agreement.
Okay, yeah, of course you do, because that's
No, I
your
appreciate
client.
that. If Your Honor would like to.
But what I'm saying to you is your plaintiff has alleged you breached that agreement.
I
right?
understand that.
And that claim is still extant, correct?
I'm sorry?
That claim is still going forward, right?
That claim has not, summary judgment has not been
Right.
granted, of
So
course.
so how can we grant you summary judgment on your breach of contract claim when we haven't decided who breached the contract first?
Because I believe, as I will get into later into the discussion, I believe that the summary judgment should be granted dismissing the respondent's breach of contract claim. So there is no question with respect to the fact that there wasn't a breach of the franchise agreements from franchisor's end. In particular, if
So essentially, you want it all. You want all your claims granted and all plaintiffs' claims dismissed.
I take one. So far in the lower court, all of my claims
Right.
were dismissed.
Right,
when they
because
should
I
not-
mean,
they
frankly,
should
if
not
you
have
look
been.
at the record, there is not a single thing that either one of you agree on, right?
No, I don't think that's true. As a case in point, we've already pointed out that we agree that royalties were not paid. Their expert says that royalties were not paid.
Right.
With respect to liquidated damages, there's been no dispute that the contracts were terminated for cause. There was no royalties that were paid.
1 second. Didn't your adversary, didn't the plaintiff assert that the liquidated damages clause is unenforceable as an unenforceable penalty?
Yeah, they did assert that, but that's not supported by the facts of the case, which are undisputed with respect to that analysis, or the case law.
Oh,
If you look
I
at
don't know that. So let's assume. So you're saying that there's no possibility that that's
There's no possibility that way, Your Honor.
okay. All right. Go ahead.
I'd like to respond to Your Honor's question. I'm just not sure that I understand it.
No, you want us to grant you judgment on a claim. First, you want us to dismiss all the breach of contract claims, which are still going on, and then you want us to, at the same time, grant your motion for summary judgment on your counterclaim. Let me ask you this. If we find that the breach of contract claims are good, you agree with me that we can't grant you summary judgment on that counterclaim because you may have breached first.
If you find that what breach of contract claims are good?
The plaintiff's breach of contract claims are valid or viable.
Well, it depends on what breach you're referring to specifically.
I am talking about, you are seeking franchise under the franchise agreement, correct? The fees that you are seeking are under the franchise agreement.
That's correct, Your Honor.
And there is a claim still right now for breach of the franchise agreement, correct?
Yes.
Okay, so if we find that that claim is a valid claim, would you agree with me that we cannot grant your summary judgment, your motion for summary judgment on the breach of your breach of contract claim, because we would still have to decide who breached first?
Not to be oppositional, but again, it would depend on what the breach is.
Fair enough.
So for example,
There's a lot of claims. Let's move on.
no, well, just for example, Your Honor.
Move on.
Yeah, because
Fair enough.
this going back and forth, asking her questions, that's not how this works.
Fair enough. I just want to be
So
responsive
make your
to your
argument
questions.
and let's keep it moving.
Understood. Okay, so we've addressed the royalties and brand development fees. Your Honor had raised a point with respect to liquidated damages and whether or not that provision is enforced.
If we find that the liquidated damage, there is a question of fact as to whether or not the liquidated damage is provision is an unenforceable penalty, then we have to let it go forward, correct?
I don't believe there is a question
All right,
of fact.
I agree, but I'm just asking you that's what the plaintiff is arguing, right?
If the question is, does a question of fact preclude a finding of summary judgment, it would be incredible for me to disagree with that.
Right.
That's Hornbook law. But what I'm saying here with respect to this particular case is there is no question of fact. If you look at the provisions itself, there's explicit agreement between the parties with respect to the fact that it's hard to calculate damages. And respondent's own case law that was cited, Ramada, shows that a 2-year horizon essentially for the damages is correct. That's respondent's case law. There's also interest in attorney's fees, but I'd like to move forward to their causes of action and get into Your Honor's question with respect to the breach of contract. To Your Honor's point, if they have asserted a breach of if they have breached the contracts as their own expert concedes that they have, then they don't have standing to assert a breach of contract. But even moving beyond that, there are several claims that were brought up in the pleadings. There were claims under the third cause of action, which have been subsumed into the second. None of those were addressed by respondent in the underlying.
Let me ask you another question. If we find that you defrauded the plaintiffs into entering into those agreements, all your counterclaims are dismissed, correct? And that fraud claim is going forward. You haven't even moved in this motion to dismiss that fraud claim, right?
This court, Your Honor, has already ruled that the franchise agreements are viable and that there was no fraudulent inducement in its prior appellate order.
My understanding was, so tell me what you think, what fraud is going forward? No fraud.
There's a claim I believe, with respect to fraudulent inducement into either the step and rights agreement or the restated note.
Right.
Those are separate and apart from the franchise agreement that we're talking about. This court, as I said before, this court has already ruled that the franchise agreements are enforceable.
Okay, so then the other two agreements, if we find that there was a fraudulent inducement with respect to the step-in agreement and the restated note, then all your breach of contract counterclaims on those, including your claim for liquidated damages, have to go, correct?
No, that's incorrect because they stem from different agreements. Whether or not there was fraudulent inducement into an independent step and rights agreement or a restated note is completely separate and apart from whether there's fraudulent inducement into a franchise agreement.
Oh, I agree.
Which this court has already ruled is enforceable.
100%, but I am saying to you that all your claims based on those two agreements, all your counterclaims.
We have no counterclaims based on those agreements.
When you're talking about, for example, the, you're right, I'm sorry, it's all plaintiffs, but you're seeking for us to dismiss the plaintiff's claims that are based on the breach of contract of the step-in agreement and the restated agreement, correct?
Yes, because
if we find that those two agreements were fraudulently induced, then plaintiff's claims are good. They survive. And any damages, right? Okay, let me ask you two more questions.
Sure.
Two more. One, the restated note.
Yes.
You want judgment on that.
Correct.
And Judge Cohen denied judgment in a 3213 motion on that, right? What ground did he deny that on?
There was a
simple question.
Yeah, no, I'm
I
trying.
can go back to the nice if I'm just asking you, why did he deny judgment on the 3213?
I think it was denied because it was a 3213 motion that was pre-discovery and there wasn't sufficient evidence before the court. But we're in a completely different procedural posture here.
Sufficient evidence of what?
Of payment of the underlying funds.
Okay.
But that was, again, I have to stress, that was pre-discovery. Here, what the court has been presented
But
with.
you've argued to us that if you look at the face of the note itself, there it is.
It is there.
And that was denied. That argument was denied by Judge Cohen, correct?
With all due respect, I think that finding was incorrect.
Okay, but I'm asking you, did he make that finding?
Yes.
And you didn't appeal that?
No.
So now you're back making the same argument before us that you made before him but lost and didn't appeal.
That is one of several arguments.
Yeah, I know, that's the problem. There's 10,000 arguments and 10,000. Okay.
When there's a lot in our favor, we like to advance all of them.
I agree. All right.
You have one more question?
No, I'll just let it go.
All
I
right,
don't
you'll
wanna
have
run
time
on.
on rebuttal.
Thank you.
You may proceed.
Thank you. May it please the court, good afternoon. Tina Glandian on behalf of plaintiffs' respondents, counterclaim defendants' respondents, and additional counterclaim defendants' respondents. I believe the court was absolutely correct in making the observation that...
Except you did continually challenge the franchise, the trademarks on the count, right?
We think there's
And you agreed that you wouldn't.
I'm sorry.
Did you,
and
you
we-
agreed that you wouldn't?
I believe the challenge is a little bit different than what was contemplated in entering the agreements. I think at the time that we challenged the validity of the trademarks, there had been a judicial finding by Justice Kornreich. that
Doesn't
they had-
matter. You made an agreement to not do that, and you did, correct?
We've
Did you not sign an agreement that says, we will not challenge these trademarks?
we believe that these were relying on the finding.
Let's start with, did you sign that agreement?
Yes, Your Honor.
And did you challenge those trademarks?
In reliance on judicial findings.
Doesn't matter if, whether you discovered the world was changed, whatever. You did something that you contractually agreed not to do, correct?
Correct.
All right, so that's one thing.
Yes, and I think there's...
Question then becomes, what's the damages?
Correct, and I was going to say, I don't think there's any damage because this case was always far broader than the validity of the trademarks. This was filed and has proceeded past the finding that they can't proceed on those claims, and there's absolutely no damages that they could point to that would have resulted from this, considering that there was a judicial finding of them committing trademark
No, that's not right. I'm not even going to, well, let's not go there, because I don't think that's a particularly good argument on your part. Well, let me ask you this. What about the $61,000? It's under the franchise agreement. Your expert says it's due, correct?
Sure. Well, let me contextualize. Our expert doesn't say it's due. There's a separate lawsuit pending in a different court between the franchisees and certain Class B investors. In that case, the court had ordered an equitable accounting. That period was limited to 3 of the entities that are at issue in this case, and the time period was 2014 to 2016. So it doesn't account for any payments that were made in 2017, 2018. So that expert report says that in that period, I believe a little bit over $1 million in royalties were due and about $950,000 in change were paid, leaving a shortfall of $61,000. It does not say that that was the payments that were ever made. So after 2016, and that's about the same time that the franchisor stepped in, started managing and controlling all the proceeds of these entities and paid itself well over $1.5 million in royalties, branding fees. So there's absolutely no reconciliation where that $61,000 falls, and that's a triable issue of fact as to...
How is it triable if your expert looked at the documents and said, yes, during this period of time, we underpaid 61? Are you saying that your expert is not correct in that?
No, but
Did you put in any proof that after that they paid themselves the $61,000?
Well, we put in proof that they paid themselves royalties that they were not entitled to under the agreements.
That's a different question.
But the franchisor stepped in and started managing these entities in November.
We all know the facts. I'm just saying, your expert agrees on the 61, right?
Our expert agrees up until a date. He didn't go past November of 2016 when they stepped in. So if payments were made in December of 2016, it's not accounted for in the equitable accounting.
So you're saying that the payments that were made after 2016 could have included that 61,000?
Yes, and
based on what? What is that? Where? That's what I'm saying. What is the evidence that you're submitting that would support that?
The evidence is that the franchisor stepped in and started paying itself anything and everything it wanted to. So if it was owed $61,000, I bet they paid themselves the $61,000 because we know.
Are we, one second, are we at summary judgment stage now?
We're
at summary judgment stage.
Yes, correct.
You have all the documents, right? Is there anywhere in the documents that show that they paid themselves that $61,000?
Yes, we have documents showing that they paid themselves, and I don't have the breakdown in front of me, but over 1.5 million, which includes royalties, so that's several hundred thousands of dollars in royalties that were paid by the franchisor when it was not supposed to pay itself, which more than offset the $61,000 that they claim is due from that period of time.
Do you have, okay.
We have the numbers in our brief, and I would submit the court that there's hundreds of thousands, well over 61,000 in royalties that the franchisor paid itself once it stepped in and took over.
Hit your other issues. You have 4 minutes left.
Okay. I think ultimately what this really comes down to is, as the court recognized, almost every fact in this case, anything that's not foundational is disputed. Even benign facts as to how the franchisees and franchisors came to enter into these agreements. So this case is going to trial. There's fraud claims, there's certain counterclaims, and I think all of the claims or the counterclaims that the franchisor is trying to get summary judgment on are examples of him putting the cart before the horse. If they materially breached the franchise agreements, which is separate, obviously, than the fraud that we're alleging as to the step-in rights agreement and the restated note. Speaking about the franchise agreements, if they materially failed to perform and if they breached those agreements, then they're not entitled to relief under the agreements. And so they're seeking liquidated damages. They're seeking interest on overdue payments and attorney's fees, things that they will not be entitled to if we prevail on our claims. So ultimately, all of these claims have to go to trial. There's disputed facts as to all of the conduct, from one party, both parties against each other. And I think all of that needs to be resolved before any party could seek to get fees or any sort of relief under the franchise agreements. We need to determine who actually breached these agreements, who's in the right, who's in the wrong, and who owes who money. And I don't think we could do that here on this record when everything is disputed, which I think, again, there's over 8,000 pages. Justice Ostrager, who's presided over this for 5.5 years, is very familiar with the case. He aptly noted that everything all the essential facts are disputed.
Let me ask you one question. Doesn't the step-in agreement allow the defendants to make distributions and bear burger for existing obligations? Are you saying that's not correct?
Correct. Our reading is not that for existing obligations, meaning any monies that was owed as of the date the step-in agreement was signed, not for obligations that accrue after that date to themselves. They can only pay for the operations of the entities, but not monies, and that's very clear in the step-in rights agreement. It cannot pay itself. And if the court has a different interpretation, then it only supports our argument that there's absolutely no consideration for the step-in rights agreement, which this court previously in its order found. And the only conceivable consideration, which they couch as a methodology provided for in the step-in rights agreement, would have been that agreement that they would not pay themselves money. And we call that fictitious consideration because they actually didn't abide by that. And that would have been the only reason they would have entered the
Has anyone made a determination as to whether or not the step-in agreement permits them to pay themselves for ongoing?
There has not, and Your Honor, we would submit that that's a triable issue. I think the language is susceptible of two reasonable interpretations. I think it would be appropriate at trial to see what the intent of the parties was in signing the agreement. For Your Honor's reference, fact depositions were waived in this case, so there is no existing testimony, and that was not addressed in anybody's affidavits. And I think, again, because it's susceptible of reasonable interpretations, that is an issue that should be determined at trial where the parties could submit appropriate evidence.
Okay. Thank you.
Thank you.
You have 2 minutes.
Yes, just a few quick points, Your Honor.
I just wanted you to address the consideration for the step-in agreement.
Okay. Well, we pointed out that under the franchise agreements, there was, I don't want to say free reign, but there was broad ability to run the franchises in the manner that the TIDM, who was the managing agent, who stepped in and ran the franchises, did. With respect to the step-in rights agreement, it says that there were restrictions on how they could run their management. So even though it's true, and what this court held before is correct, that they had the ability to step in, that they had the ability to run the franchises both before and after the step-in rights agreement, and that does not constitute consideration. The additional shackles, essentially, that they've put on themselves do constitute consideration under prevailing case law, which says that consideration can be minimal and that it can be an additional responsibility that's been taken.
And what, tell me again what these shackles were?
They had to maintain all of the funds that were generated by the franchises, with the exception of funds for existing obligations. So, which dovetails into another point.
How is that a I mean,
that's an
isn't that the same thing that Bear Burger had to do?
I'm sorry. Can you say that again?
I thought I read, and I would have to shuffle through this to find the.
I think I understand your question, Your Honor. It's essentially if you were to do a side-by-side comparison of the step-in rights provision in the franchise agreements, which is where the authority originally originates from to run the franchises, against the language in the step and rights agreement with respect to the powers that TIDM, who's the managing agent, has. You would see that the obligations, or I'm sorry, the rights in the step and rights agreements are narrower. And the case law is clear that
How are they I keep on asking you for
Yes.
the particulars.
right, they don't have the authority under the agreement to do anything other than take out under the step and rights agreement, other than anything to take out funds for existing obligations, which is not a prerequisite under the step and rights provision of the franchise agreement.
That's the consideration? That's
Wow.
what you're calling is the consideration?
That is like the biggest stretch I've ever heard.
Okay.
Wow. Okay.
All right.
Thank you. We'll take it under advisement. Trust me. Okay, Doe versus Wilhelmina Models. You may proceed.
Good afternoon, Your Honors. May it please the Court. My name is Greg Feit of Revis Page Jump on behalf of Plaintiff Appellant Jane Doe. In reviving time-barred civil claims based on child sexual abuse, the New York Child Victims Act had a remedial objective of unlocking courtroom doors. Legislative history says unlocking the courthouse door. Yet when the court below considered Doe's amended complaint, it not only kept those doors shut, it bolted on an additional lock, plural locks even, because the decision was multiply flawed. First, it runs directly counter to a recent and now controlling precedent from this very court, which was decided only a few weeks ago, and which was the subject of a still pending motion for leave to file cert reply. Second, it misapplied the CVA by imposing age limitations that are not in the statute itself and that are harsher than the age limitation in the statute itself. And third, the court's decision overlooked critical, well-pled allegations. If I may, I'll start with the recent precedent. So as I mentioned, and as this court knows, this court recently held, after all briefing had been submitted in this matter, on August 24th. August 24th, rather, is the date of decision, to be clear. In Samuel W. v. United Synagogue of Conservative Judaism, that the CVA applies to injuries committed out of state, out of New York, when the plaintiff victim was a New York resident at the time the alleged sexual abuse occurred.
In this case, your amended complaint alleges that the plaintiff lived in New York, right, before the abuse occurred.
Right.
She was in Florida. She flew to New York, started residing with a roommate or some other person, and then from there went to Mexico, right?
That's correct, Your Honor. Yeah, we feel that the amended complaint's allegations are amply sufficient and specific. We say that Doe, quote unquote, moved from her parents' home to New York City in order to pursue a modeling career. So you can infer an intent from that it was not some brief
Oh, you assume
visit.
it's true for the pleading purposes. It's assumed true, right?
Right, it's assumed true, and it also needs to be liberally construed, Your Honor, as you know, and every possible favorable inference has to be accorded to the appellant, the plaintiff here. We also allege that upon relocating to New York City, she moved to an apartment. She lived in Manhattan with other models, and we say that she later, after she was fortunate enough, in one sense, to get a job quickly as a child model. She had a job, she went to Mexico. After enduring what we say is traumatic sexual abuse, she went to visit her parents' home in Florida. And the law is also clear that a plaintiff can have more than one resident. This is not domiciliary status, this is residence.
Let's move on to some of the more harder issues. I mean, let's assume the CVA applies, right, and that you've satisfied the CVA requirements. How did your causes of action let's take Caltan first, with respect to negligence and breach of fiduciary duty and invasion of privacy stack up. I mean, why should those be reinstated? I mean, you take one, the makeup artist first, right? The allegations against the makeup artist.
Right. They should be reinstated, Your Honor, because the complaint pleads viable causes of action for negligence, among other things. Negligence, a duty of care arises from special relationships. Here we have a situation where these agencies and Caltan, the Caltan defendants, pardon me, Wilhelmina and the Caltan defendants were entrusted with the
Let's keep them
supervision.
separate. Those are two, we got two defendants going forward, so you gotta be careful when you try to merge them together. That's not gonna work too well, at least in my mind.
Okay.
Let's do a Caltan first, right? Caltan, the makeup artist. Let's go with that. Why do you think that negligence and breach of fiduciary duty claim and invasion of privacy should be reinstated?
I'm sorry, I wasn't trying to conflate the two. I was just saying that the same general principle applies. But
I'm
as to
I'm not gonna let you conflate them, but okay.
as to Caltan and the makeup artist, a duty of care arose because the Caltan defendants took a 16-year-old to Mexico on a 5-day photo shoot, and they had a duty of proper supervision over her. They had a duty to provide adequate supervision. And it was well known, and we allege at least that
Wait,
it was
for
well-
under what cases do they have that duty? They're not her parent. They employ her, right?
you can analogize to
No, I'm just asking you, are there any cases that say something like that?
you can analogize to the cases involving church dioceses where kids are entrusted to the care of a diocese.
This is an employee-employment relationship, right? It's not me going on a Boy Scout trip. It's Caltan is paying her to model, correct?
That's correct.
So I'm trying to figure out, where does the duty arise?
Well, the duty arises. There's a respondeat superior duty because they were acting within the scope of their employment, that the makeup artist was touching, under the pretext of applying foundation makeup, she was touching the plaintiff victim. So that was not solely.
Let's assume that you've alleged sufficiently that that you have, all the relationships and you alleged and they're there. Is there an allegation against Caltan that they knew the propensity of the makeup artist, that they knew that the makeup artist was, a sexual predator?
There are no such allegations specific to any specific employee, but there are allegations that it was well known within the child modeling industry that.
But you're going after Caltan. I mean, you need to have something.
Were the allegations here that during the rubbing of this lotion on her body, that there was another person present observing?
Yes, there are, Your Honor.
And so they observed this young woman squirming at the touching of her.
Yes, Your Honor.
I mean, the way the plaintiff describes that incident seems to infer that she was visibly uncomfortable.
I'm sure she was. I don't believe that's specifically alleged in the complaint. But we do allege that it was highly traumatic for her, and we allege that at the photo shoot in Mexico, she was plied with marijuana, a 16-year-old.
But that's not a CVA case, right? That's not covered under the CVA.
No, I just mentioned that for context.
How about the invasion of privacy claim? Is that covered under the CVA?
Your Honor, I would be willing to concede weakness on that claim. I do think that the breach of fiduciary duty and negligence claims.
Right, okay, what fiduciary duty do they owe to her? How is Caltan her fiduciary?
I'm sorry, I was again conflating. I believe that the fiduciary duty point applies to
Wilhelmina, okay, fair enough. I'm talking about Caltan. You've alleged breach of fiduciary duty, negligence, and invasion of privacy, right?
Right. I mean,
So we agree that invasion of privacy isn't a CVA revive claim. Negligence, we've already discussed. Now I'm trying to figure out where's the fiduciary duty.
Well, fiduciary duties can also arise from special reposition of trust, reposing a special confidence.
She's
in a
their
party.
employee, right? She's an employee.
Was there any agreement in the agreement between Wilhelmina and Caltan or Sunshine, whichever one signed the contract for this model shoot in Mexico? Was there any language in that agreement with respect to the models being sent by Wilhelmina that Caltan or Sunshine was assuming any responsibility for this underage model? Is there anything in that contract that would support a fiduciary duty claim?
I'm not aware of anything, Your Honor. I mean, I may have misunderstood your question. There are allegations that separately support that with respect to Wilhelmina, not with Caltan. I think you were
Okay.
asking solely about
Right.
Caltan.
All right. Thank you.
Thank you, Your Honor.
Good afternoon, Your Honor. Andrew Nordall of Smith, Gambrell, and Russell on behalf of the defendants/respondents. May it please the court.
All of them or one of them?
Excuse me, yes, two of them, actually.
Yeah. Caltan, are you the
Caltan
Caltan?
LLC and New Sunshine LLC. And that brings me to my first point. Thank you. A revival statute such as 214G is a special law, and it has to be construed very narrowly. And at every turn, every decision has to keep that in mind. And the reason for it is such an awesome power that the legislature has to revive these cases. Our clients got caught up in this because back in 1993, 30 years ago, a California company called California Sun Care went to New York to hire a model. Had nothing to do with Wilhelmina. I think they dealt with some previous modeling agency. Nothing to do with Wilhelmina at all. And they hired a model, and they had a shoot down in Mexico. Then in the year 2000, just on the corporate timeline, year 2000, an Indiana corporation purchased California Sun Care. Then years later, in 2006, completed in 2007, a different Indiana LLC, New Sunshine LLC, acquired the Caltan Inc.
Okay.
And they created Caltan LLC to operate Caltan Inc. And obviously, they had nothing to do with any of the hiring, et cetera. And this is brought on a purported.
No, but I mean, but the allegation is that the makeup artist that was hired by Caltan 30 years ago sexually abused the plaintiff, right?
The allegation is California Sun Care hired.
I mean, and we agree that you are the successor corporation.
We do not concede that.
Are you saying that you have disclaimed, there's some kind of agreement by which you have not retained the tort claims?
There was an acquisition, and it is we don't have the original papers.
Then you can't argue that now. Let's maybe
we
you'll
plan
put
to
up
litigate
that
that
argument
with
and
the
say I
court.
didn't retain the tort claims. But we're talking now about whether or not there's a breach of fiduciary duty and a negligence claim against your client.
Understood, Your Honor. There is no allegation in the complaint that the makeup artist is an employee. The makeup artist was accompanying the photographer on the shoot, but there's no allegation that she was an employee of our client's predecessors, to answer your question directly.
Well, if the photographer bought the makeup artist, I don't think that gets you off the hook. Okay?
I'm not suggesting that, Your Honor.
You throw that out there for a reason, and I'm letting you know, if the photographer bought that makeup artist who then abused this young woman, you own that.
Well, Your
At
Honor,
least for the purposes of this. You can work it out on trial.
Your Honor, we can dispute, I think, that these acts are covered under the CVA. 214G, as I said, it's a revival statute. 214G is not the CVA as put forth by the SH court and the W court here in the First Department. That was an issue of first impression here in the department, and the W panel treated the SH decision as virtually a controlling decision, adopting its findings, and the SH decision is problematic to say the least. Number one,
No, but I mean, here's the allegation. The allegation is that the makeup artist repeatedly rubbed makeup on the breasts, buttocks, back, and thighs and stripped plaintiff of her bikini top, all without her consent. And why doesn't that cover sexual abuse in the forcible touching and sexual abuse in the third degree, which is something that's covered under the CVA? Really, the question, I mean, I think it is covered by that, but let me just ask you this. What about, do you think that there are sufficient allegations that your client knew or could have any idea about the propensity of the makeup artist to do that?
to answer your question directly, there are 0 allegations that our clients, our predecessor, had any inkling as to the predilection, the tendency of this makeup artist. But getting back to whether it's covered, it's not. The CVA applies to conduct that constitutes an offense under Article 130 of the penal law.
Right, so sexual abuse in the third degree, Penal Law 130-52, right? Forcible touching.
Rubbing your hands all over my body without my without her permission constitutes sexual abuse under our penal law.
Only if it happened in Indiana. The Indiana penal law does not apply.
That's your argument, counsel. I don't agree with that, but
it is.
By all means.
If I can expand on that, Your Honor, the phrase constitute an offense, conduct, NY Penal 20.0, criminal liability for conduct of another. When one person engages in conduct which constitutes an offense, another person is criminally liable.
Wait, are you saying that we have to apply both penal statutes?
I'm saying that the legislature had the definition of conduct that constitutes an offense in mind. They're presumed to know what that meant in their own statutes.
Right.
And that language appears throughout the penal.
Right, but so where is it that you are talking, why are you talking about the Indiana Penal Code?
I'm not talking about the Indiana.
Oh, I thought I heard you say.
Oh, I apologize. New York Penal Code. No, our clients at the Indiana. I'm talking about the New York Penal Code. That phrase is throughout the Penal Code, and
what phrase are you saying is throughout the Penal Code now?
Conduct constituting an offense.
Again, and so what I think we're disagreeing with is you're saying that forcible touching under 130 wouldn't, what the plaintiff alleges wouldn't constitute forcible touching?
It would possibly in Mexico's statutes, but we're talking about New York statutes, ma'am.
Right.
The conduct has to constitute an offense under Penal Law Article 130.
Yes.
The jury instructions for each of these sections, the number one element is that it happened in a county in New York.
Okay. But I mean, we've just said that we're bound by our own precedent here, right? Samuel W. said we are not limited by the territorial jurisdiction of New York.
I will address the Samuel W. case. In W, this court actually took it a step further. This court took the SH ruling and added something that has no...
I'm going to give you an extra.
Thank you very much.
You asked me. I'm in the center
I appreciate
chair.
it. The W court added in expanding upon SH by saying every covered civil claim or cause of action that would have been properly brought in New York in the first instance. That phrase appears nowhere in the statute, in the CV, the enacting legislation, the statute, the case law. There is nothing to back up that sentence.
Thank you.
Good afternoon, Your Honors. If it pleases the court, Matthew Hurdy on behalf of defendant respondent Wilhelmina Models. I'd first like to address plaintiff's improper raising of claims of negligence and breach of fiduciary duty against Wilhelmina for the first time in plaintiff's reply. Those claims are not addressed in one half of a sentence in plaintiff's initial appellant's brief. The breach of fiduciary duty appears not once. This concept of constructive notice, that phrase does not appear one single time in plaintiff's initial brief. Those claims about in which plaintiff objects to the trial court's ruling about her theories of negligence and breach of fiduciary duty, those issues have been waived. It is improper and impermissible for an appellant to wait until her reply to raise issues such as those. Plaintiff cannot contort this process by creating a moving target like that. So the issues of negligence and breach of fiduciary duty have been waived. With respect to plaintiff's allegations that her complaint alleges sufficiently that Wilhelmina used plaintiff as a child in a sexual performance, there's a number of reasons why that argument fails. There's a number of problems with her position there. Plaintiff was never within the age limit of the originating statute, or rather the predicate statute, section 263.05 of the Penal Code, which specified.
But that's not, I mean, that would be turning the CVA on its head, right? If we are going to make the assessment based on the old statute, then what's the purpose of the CVA?
Well, the CVA had a lot of purposes, Your Honor. The CVA revives claims that existed at the time of the conduct alleged.
Right.
If Your Honor is addressing what plaintiff characterizes as a conflict between the age limit set forth in 263.05, and that age limit is also set forth in 263.00 in that statute's definition of the word sexual performance. If we're talking about what plaintiff characterizes as the supposed conflict between the age limit set forth in the Penal Code and the phrase in 214G, which conduct was committed against a child less than 18 years of age, if that's what Your Honor is referring to.
Right.
I've addressed that in our brief.
Okay.
That 214G language, which conduct was committed against a child less than 18 years of age, is not referring to conduct which constitutes the use of a child in a sexual performance as defined in section 263.05. If you look at the way that the language is written in CPLR 214G, that language...
So what do you think it applies to?
It applies to the phrase that is directly before that is between two commas directly before that. It's the sentence I think is best read as follows. I'm going to paraphrase somewhat here. Every civil claim alleging injury as a result of conduct which would constitute the use of a child in sexual performance as defined in 263.05 of the penal law, or conduct which would constitute use of a child in sexual performance as defined in a predecessor statute, which conduct was committed against a child less than 16 years of age. The which conduct which was committed against a child less than 16 years of age refers to the phrase directly before that or a predecessor statute. It makes no sense to conclude that the court that the legislature so obliquely sought to override the clear legislative age limit of 16 until the statute was amended in 2001 when the age limit was raised to 17. In any event, the plaintiff was always older than 17 when her relationship with Wilhelmina was ongoing. It is...
So you're saying that it didn't, but so the question is whether it's, why put in the 18 in the statute? What could it possibly do? Doesn't it seem clear that it's intended to raise it from 17 to 18 with respect to these with these revived claims?
Your Honor, absolutely not.
What is it for there?
It's referring to if Your Honor is looking at the statute, the language of the statute as I am, the statute says,
Well, when do you think it's okay to be between 17 and 18 and revive your claim? Let me make it easy.
sure, under some predecessor statute that is not at issue here. That's what the language "which conduct was committed against a child less than 18 years of age" refers to. It's the conduct which would constitute the use of a child's sexual performance as defined in a predecessor statute. That's, to me, the only logical reading. And if that isn't enough for Your Honors, it is still the case that in order for plaintiff's argument to prevail, that this, which was committed against a child less than 16 years of age, overrides the clear state age limit set forth in 26305 and 26300, it's not logically sound, Your Honor. Those two phrases can coexist because conduct which was committed against a child less than 16 years of age is also conduct committed against a child under 18 years of age. You would just have to satisfy both, which did not happen here. It's inconceivable, Your Honors, that the legislature sought to override the age limit in two separate places. Let me point out very clearly that sexual performance is defined in section 263.00 as sexual conduct by a child less than 16 years of age, which definition is then repeated in 26305, less than 16 years of age. It happens twice. To argue that the legislature overrode that so obliquely, it doesn't hold water, Your Honors.
Okay.
I'll start in reverse order with Wilhelmina's arguments. The notion that we somehow waived any arguments by not raising fiduciary duty and negligence in our opening brief is frankly nearly preposterous.
Well, we typically don't entertain arguments that are raised for the first time in reply, so that is not so preposterous.
But it is preposterous in this case, Your Honor, because we responded to the lower court's decision. Respondents had the right, which we don't contest, to raise any other matter in the record that they believe constitutes another ground for affirmance of the lower court's decision. They did that. We then responded. We did not waive anything, and we certainly should have had the right to respond to what they wanted to raise as additional grounds for affirmance. We could not have predicted their arguments in our opening brief. Next, as to Wilhelmina's age limit argument, it suggests that the better reading is theirs. I'd like to walk the court briefly through 214G, if I may. We start with language saying, as a result of conduct which would constitute a sexual offense, ellipses, ... or the use of a child in a sexual performance as defined, ... comma, or a predecessor statute that prohibited such conduct at the time of the act, comma, which conduct was committed against a child less than 18 years of age. So let's go to the last two conducts.
The or before the predecessor seems important.
It does, but what is also important, Your Honor, is that the term conduct in the such conduct and then the final which conduct are functionally the same. They have to be functionally the same because it's such conduct, which conduct. So if they are correct that such conduct on the predecessor statute automatically inherently incorporates a different age limitation than under 18, then it's not the same. Which conduct is not the same. It makes no sense on their reading. It's illogical. Now to Caltan. The Caltan defendants suggest, they point out that some case law has indeed said that revival statutes must be construed narrowly, but not so narrowly that the plain language of the statute is ignored. Pardon me, Your Honor.
Well, I mean, isn't it basically that we're bound by Samuel W.? And if
Yeah, I don't
they're,
think
then
there's
the thing for them to do is go up to the Court of Appeals, not for us. We're bound
Yeah.
by our own decisions, right?
You're right. I don't want to squander the court's time on that point, but I can if
Thank
you'd
you.
like.
Trust me, we have the record and the briefs, and we will be plowing through it. Thank you so much. Okay. Okay. No, they're not. I'm having a hard time. All right. People of the State of New York versus the National Rifle Association.
Your Honor, and may it please the court, Noah Peters for the National Rifle Association. The lower court wrongly applied the standards from Hartman versus Moore and Nieves to essentially insulate any retaliatory action undertaken by the Attorney General, so long as the Attorney General could later point to some probable cause for her action. Historically speaking, the retaliation, First Amendment retaliation, requires an actual inquiry into what actually motivated the government actor to take the decision. It does not allow pretexts, and it requires at least some consideration of how the decision was actually made. And the dangers of a contrary rule are obvious. It creates a dangerous precedent, the lower court's decision does, that would allow state regulatory agencies, officials, to retaliate at will so long as they could later point to some probable cause for their actions. If we go back.
So hasn't the 11th Circuit found that this standard applies to civil enforcement proceedings? The Hartman, I guess, Neves, those two cases?
Those two cases
And the 10th
are.
Circuit has also said that standard applies to civil enforcement proceedings?
The 11th Circuit cases are inapplicable because they apply to cases where there's two different actors who make the decision or who are involved in the decision to bring the counterclaim.
Are there
So-
any cases that say go the other way?
Yes, there are plenty of cases.
Which cases are those?
So Care Partners versus
I guess what I think is interesting is that it seems like there may be a split in the circuits, right?
Yeah, I mean, it's a novel, in some ways a novel question, although I strongly believe that the 11th Circuit cases do not provide support for applying Hartman and Nieves in this particular context because those are two-actor cases. So in one of the cases, DiMartino, the city, there was a scheme to basically fraudulently extract settlements from the city by filing all these different FOIA actions against them. And the city was being crushed under the weight of all these lawsuits. And they thought, how can we go ahead and stop this from happening? So given the incredible burden that the conduct was placing on the city, the court held that the speech was a legitimate consideration for the city to take into account. Here, the NRA's pro-Second Amendment speech is not a legitimate consideration for any purpose in deciding how to administer the charities laws against it. There is also a particularity in that case where the city was very cautious and it said, we're going to have an outside law firm I think actually.
Let me just ask you, are you saying that the AG had no probable cause to investigate?
No.
What about all the public information concerning the NRA?
Well, right.
We start with right? You're licensed here in New York as a charity, right?
Right.
So that means you get a lot of benefits, correct? Charities get a lot of benefits under New York law.
We do get benefits.
Okay, and we all agree that the AG has the authority to investigate charities to make sure that they are not abusing their benefits, right?
Of course.
Okay, so we start from that, and you're saying, given all the information, I mean, the complaint's pretty detailed and it's long, you're saying there was no probable cause to investigate?
Well, the problem is that the Attorney General announced her intention to take action against the NRA's charitable status long before any of that evidence came to light or there was any media reporting. These statements very clearly linking the NRA's advocacy, calling it poisonous, in saying that she was going to investigate the NRA's legitimacy as a New York non-for-profit. It very clearly links her animus to the investigatory and the decision to bring a suit. Now, the fact that later, about a year later, evidence came to light is not. I mean,
you're making that argument. I don't know that that is an accurate and true statement, that it's only a year after she made those statements that there was evidence of the misuse of charitable monies by various leaders of the NRA.
Well,
that was public information and being discussed on all sorts of news outlets, both in print and on television.
Well, so the revelations came to light as a result of the Attorney General's investigation. But the other thing is, this is still at the
Wait, are you saying there was no public information available? There was no public discussion? There was no public allegations about malfeasance on the part of the NRA's board and chair, I think, prior to the AG's investigation?
In 2018, when she made the statements, there was not.
Okay.
And so, but
I guess we can just look at the record and see whether that, because I think the AG might disagree with that.
Well, but
let's assume that there was. If there was predating public information, would your argument still hold water?
If there was information that predated her, if the sequence was information comes to light saying, indicating that there are problems with the administration of the NRA, the Attorney General says, I think that these, that an investigation is warranted. Afterwards, that obviously is a very different case.
Okay.
But I would also say that the particularities about when the Attorney General knew information and what caused her to investigate are matters that are way, way, way premature, because we're just going and I think one of the key points here is that the lower court dismissed this straight up on the pleadings. There was no discovery, nothing. And so I
dismissed the dissolution claim, yeah.
Well, he dismissed the dissolution claim and also dismissed the counterclaims, which we're now appealing, but that was also on a motion to dismiss. There wasn't any discovery, there wasn't any there wasn't any attempt to gather evidence. It was really just on the basis of the pleadings. And I would also note that he wrongly believed that absolute immunity would have barred the relief we were seeking, even though the relief was primarily injunctive in nature. And I think at a minimum requires a post-discovery inquiry into what the AG knew and what the motivations were, because the statements that the AG made before she had any reason to suspect any sort of wrongdoing, and then the fact that the investigation was opened very quickly afterwards does indicate, at least is evidence, direct evidence, very good evidence, that there was some illicit motivation, at least in part, motivating the decisions. And so that requires a very sensitive inquiry into what actually happened. And the lower court cut off that inquiry, which are both criminal cases, do not apply in the context of an attorney general's exercise of her regulatory powers, including there's no dual actor problem, there's no issue that
I'm going to give you time on rebuttal because you've gone way over your time. And not looking up doesn't give you a pass. Have a seat. You may proceed.
Good afternoon, Your Honor.
All right, so I have to ask you first off, in the complaint, are there allegations of pre-existing information to give the Attorney General knowledge or notice that there are claims of malfeasance?
For the investigation, absolutely. I think the timeline is very important for that. There were first.
Well, counsel says no, there was nothing out
I mean, that's
there.
just not correct, and I can explain a little bit about the timeline. In November 2018, the NRA filed one of its annual required filings, and that filing had some red flags in it with strange transactions suddenly being disclosed, which raised questions about those related party transactions and also why they hadn't been disclosed in prior years. The Wall Street Journal then picked up on those red flags and published an article about them in November 2018. Then, a few months later, on April 12, 2019, there was a big, shocking article in the New Yorker going on explaining, based on, according to the reporter, inside information from documents and people inside the NRA, that hundreds of millions of dollars of charitable assets had been getting funneled through or to private individuals, including high-level leaders at the NRA, their friends and family, and for-profit vendors like Ackerman and the Brewer Law Firm. And it was only after all three of those things that the Attorney General's office opened its formal investigation on April 26, 2019.
And did the Attorney General herself say anything about investigating the NRA prior to November 18th?
During the campaign for Attorney General, which was in the summer of 2018, I think a lot of the statements that they point to start in 2018. We do not agree at all that if you look at those statements, they are not saying clearly, I am going to, what she was saying in context was, yes, charities enforcement is going to be a priority if I am elected. She did say that she would look at not only the NRA, but also other charities and officials who might be giving money to charities that they were involved with, that she wanted to look to see if the NRA or other charities had violated the charities law.
What other charities did she name besides the NRA?
She mentioned crisis pregnancy centers, and she also mentioned public officials who might be taking money and funneling them to charities that they had personal involvement with. And this was an issue that had been asked about, at least a couple of the, not all of them, but a couple of the statements that they point to. There was at least one article where the reporters were asking, not just then candidate Tish James, but also all the candidates about charities enforcement. And so a lot of these statements were in the context of interviews or a debate, and the Attorney General is allowed to, especially as a candidate before she even took office, to have her own political views and to say what an enforcement priority might be. What is important is that the investigation of the office did not open until after all of this public information came out. It is the Attorney General's office's statutory obligation to supervise charities and to investigate those kinds of public allegations, no matter what kind of charity.
So is it your position that once the public information came out, that that provided the justification for the investigation?
Yes, absolutely.
And there was no investigation during the time that she was campaigning and saying, I'm going to look at all these charities that, okay.
Yeah, I mean, when she was a candidate, she couldn't have opened an investigation. The formal investigation, I will say that the Attorney General's office, does get these annual filings and looks at them, and that may have been happening around the time that the filings came in. But that's sort of separate from opening a formal investigation with subpoena power
I
and
can't
all
help
that.
but think that I was listening to the arguments of your adversary about how probable cause and so forth, that sounded like it's almost a condition precedent that he's looking for before the Attorney General can even open an investigation or go forward with an investigation. And I'm not so sure that's how this law, I'm not so sure that's how the statute and the duties of the AG is. I mean, they conduct an investigation, they commence an action, that's where you test the probable cause aspect, is when the litigation starts. Not requiring the AG somehow explain beforehand what I did, how I got my ducks lined up in order, and this is why I'm starting. I mean, I don't think there's any law that requires that.
I agree, Your Honor. I mean, I will agree that to start an investigation, there does need to be we agree that there should be some reasonable basis for it in the very loose sense. If you look at American Dental or Anheuser-Busch, in cases where they apply the presumption of regularity, which does apply to civil proceedings, there may need to be some, yes, there needs to be some basis, but you don't need to prove up your case before you've done the investigation. You don't need to predict, you can't predict what you're going to find. I mean, I agree that we are also very far from the
But do you-
investigation at this point.
Do you agree that if there was nothing out there and the Attorney General investigated anyway, that would be a different situation?
Possibly. Yeah, if you had absolutely zero basis whatsoever to do an investigation, I think we would have a different, yes, we would have a different case. But we're not even remotely close to that. And I do agree, Your Honor, that there is sort of there's also a different standard for, you need less basis to start an investigation. You may need something, I agree, but you need less of a basis to start an investigation than you do to file claims. By the time we got to filing claims, the Attorney General's office had conducted a 15-month investigation, including gathering and reviewing documents, interviewing witnesses, and then detailed in a 170-page complaint what it had found. I do want to address the concept of the lack of probable cause applying in civil proceedings. We don't think that the circuits are actually split on this. Not every circuit has ruled on it, but the ones that have said that it applies to civil proceedings. This also goes back pretty far in New York common law. If you look at the common law in cases like Burt and DLA Piper, those are talking about the tort of wrongful civil proceedings and what you need to plead that. And what you needed was to show that the civil proceeding that you were challenging as being retaliatory or wrongful lacked probable cause. And they define that in the civil context as lacking any objectively reasonable basis. And it also makes sense to have this rule from Hartman apply to civil enforcement proceedings for several reasons. One is the presumption of regularity that I mentioned. It's very well established in New York law that applies to civil proceedings as well as criminal. It's also the case in civil proceedings, as in criminal, that the court has a wealth of information already before it right now to decide whether or not the civil proceeding had a reasonable basis. You could look at the complaint, which is long and detailed, and you could also look at the timeline and what was available in the public before the investigation started.
Wait, are you saying that no court has said that the probable cause standard only applies in the criminal context? I think that's what you just said.
But specifically, I'll be more specific about it. I think as to civil enforcement proceedings, as to lawsuits. So DiMartini and Macbeth are about civil lawsuits. The cases that the NRA points to are largely employment retaliation cases, or they do also point to some regulatory, cases that involved an agency or a regulation, but not the filing of a civil lawsuit and then claiming that the civil lawsuit is the thing that's retaliatory. And I think that's actually important because having a civil enforcement proceeding is much more akin to a criminal prosecution than it is to a general, are we looking at everybody's permits and making a decision about time, place, and manner. And when it comes to civil proceedings, civil lawsuits, you have the presumption of regularity, which doesn't always apply to something like a false arrest, where the Supreme Court has said that the lack of probable cause requirement applies. And the last thing I'll say, I can see that my time is up. We think it's really the NRA that's asking to be treated differently here. I think any charity that has the kind of highly public allegations made against it of the looting of charitable assets for the personal gain of its leaders should be subject to investigation, and if the facts warrant, enforcement claims, no matter what their politics are and no matter what the Attorney General's politics are.
Thank you. You have 2 minutes.
Yes, thank you, Your Honor. So I think it's important to look at the timeline as pleaded in the answer, which shows that the NRA was already under investigation by the state of New York in 2018 for something very different, which was, allegations.
Yes, but that wasn't, that predates her taking office you're talking about.
Right, but when she was saying, I want to shut down the NRA, she was referring to that other investigation and saying, I want to build upon what's already going on in terms of New York issuing guidance to insurance companies and financial providers, don't do business with the NRA or be very, very cautious because they advocate for gun rights. So I think that there's definitely a need for more discovery when we're talking about the timeline and what the Attorney General...
Correct me if I'm wrong, but that was all during the campaign. When you
Yeah.
make those comments about, I want to take down the NRA and all that kind of all those kind of commentary, right? That was during her campaign.
Right, but
general.
yeah, but I mean, the NRA
All
had
politicians are going to say whatever they can to get the votes, right? I mean,
but
that's what's going on.
they are, but that does not justify.
No,
you
but
know,
it happens. But then it's after the fact as to what happens in it, and it's based on, as counsel said, there were numerous articles out there that propelled or compelled her to go and launch an investigation.
But those articles were all much later in 2019. But I do want to emphasize that there was already an investigation.
I don't think that that fact helps you.
Right.
Okay? I frankly think that that hurts you because the fact that she gets elected and then jumps into whatever work they had already been doing, I don't understand.
We allege plausibly that that Cuomo and all other officials had already launched and Department of Financial Services had already made clear that they were going to try to take out the NRA in 2018. And the allegations over which this action was pursued were nowhere near being publicized at that point, or were not known. All of which I think shows that there's a very, very dire need to establish what the timeline is. I think that our pleading shows a very strong official policy by many New York actors to go after the NRA for any reason that they could find. And so with that, we strongly urge that the lower court's decision be reversed. Thank you.
Thank you so much. Have a good evening, everyone.